Petitioner,
Petitioner, my lord.
but the petitioner submits that he has filed an affidavit in opposition
My lord.
to the counter submitted on behalf of the respondents,
And my lord, two miscellaneous applications for implement and interim order.
as well as two miscellaneous applications. The rest is that to tag the same with the writ petition and list the matter after. You have anything to say?
For the respondent lordship,
Yes,
today there was an order for production of the original documents.
so you
I have brought the original document.
keep the original record available on the next date. List is directed to tag the applications, counter as well as the applications with the file and list the matter after 3 weeks.
Can it be a little earlier, my lord? There's some urgency in the matter.
Not possible, sir. Either you argue it today. We are ready.
We are ready to argue. I'm ready to argue, my lord. Otherwise, I'm ready to argue, my lord.
It's not possible. Thank you. Not possible before 3 weeks.
Right.
Yes.
May I please the lordship?
Yes.
Lordship, I beg to mention item number 10.
Yes.
Lordship, yesterday only we have filed a adjournment application, but we could not get a consent of the other party. But overnight we have contacted them and they have agreed to it.
And counsel for the respondent has moved an adjournment slip. The appellant's counsel, he states that the appellant's counsel does not have any objection. List after 2 weeks, for 3 weeks, or rather let it be after 4 weeks. Okay. Yes.
May I please your lordship? Lordship, my item number is 7.
7, Madam B. Court master called out items numbers 1 to 8. Yes, what do you want?
Lordship, I want time
Why?
to file in.
This matter is pending for admission since 2021. Seems you are not interested in pursuing the matter. We should adjourn it sine die. Let it come up when you move an application, when you are really interested to argue the matter. Is it okay?
Mm.
Then what is the justification? 2021 admission file. Today again adjournment is sought. Why do you want an adjournment? Let us know.
Time to file an IA.
For what purpose?
We need to make party to Rajiv Gandhi University.
Implement. And counsel for the petitioner submits that she is desirous of moving an implement application. She prays for and is granted 6 weeks time to do the needful. List after 6 weeks.
May I please your lordship? I beg to mention item number 12 and 13
Yes, please.
for the adjournment.
Why do you want an adjournment, Mr. Counsel?
My,
You are for the respondents.
yes, I on behalf of K. Majumdar,
Yes.
senior counsel is out of the town for an adjournment.
That cannot be ever a ground to get the matter adjourned. There are so many other seniors. They can be engaged. The matter is never sought to be adjourned on the ground that this senior, at least a designated senior, is out of town. He is not tied to any brief. All right, then counsel
Obliged.
for the respondent has circulated an adjournment slip. The other side has no objection. List up to 4 weeks.
May I please lordship? Lordship, I beg to mention item number 21.
This is for orders. Why do you want an adjournment?
Senior counsel Mr. D.K. Mishra, who is leading for respondent 1 to 3, Malak, he is under bereavement.
Okay.
His brother-in-law.
It is stated that senior counsel, Mr. D.K. Mishra, representing the response numbers 1 to 3, is suffering from bereavement in the family. And thus matter may be adjourned. List up to 4 weeks.
Much obliged.
May I please your lordship? I beg to mention item number 27.
Yes.
My senior is out of town, your lordship. We have filled up the adjournment slip.
Counsel for the
Taken
appellant.
consent.
Petitioner, review petitioner has amicus
Yes, your lordship. 1 week, your lordship.
has moved an adjournment slip. List up to 3 weeks.
Much obliged, your lordship.
Yes. Start.
I've been told that GAD is a necessary party. GAD is a party,
We are not.
so we have not furnished a copy.
No.
So I think I think 2 cases your lordship will dispose of on this line.
Of same
One
nature.
is similar, but I think there one case your lordship has issued a notice Another case, the advocate general appeared, your lordship said that go and
Make a
represent
representation.
before the delimitation committee.
Right.
Now, my lord, what I have said, I have seen my lord, the press note. I think it is not a part. Last night I came to know about press is released. 1st of January 2023, my lord, it has come into effect.
So
if
then
your
now
lord-
there can't be any change.
Now yes, now only for circumventing, that's why I want to bring it.
Hmm.
Now, if your lordship looks into the impugn notification which has been issued, is totally contrary. There is I absolutely agree to it. It's a policy of the government. Inconvenience, my lord, kindly 19.9 kilometers the village. Why have to DC code 40 kilometers? This I will argue, my lord. Let them. I'll give a copy to them first.
All right, then senior counsel, Mr. Das, representing the petitioners, shall supply copy of the writ petition to the government council. So and so, what's your good name, sir?
A. Fukan, your lordship.
A. Fukan, representing all the respondents,
Lordship, I'm representing 2 and 3. I'm the-
respondents numbers 2 and 3. Madam is for
One.
respondent number 1. You also received the copy? Okay,
Only two.
Well,
the respondents. Respondent number 4, who would be representing?
I am appearing for 1, 3 and 4.
1, 3 and 4.
Yes.
Okay,
I'm for 2.
you are only for 2.
Only for 2, man.
Then counsel for the respondents may complete their instructions by the next date of here listing. Re-notify after 4 weeks,
Yes,
4 weeks.
deeply agree.
Item number 2.
Yes,
Balance.
yes, please.
Lordship.
District,
Lordship. On-
same issue,
Lordship.
delimitation,
My lord, I've given a copy of the on order.
similar order.
Similar order, my lord, on the last, yesterday this matter was taken up. Similar order may be passed on. PL 23 loss.
All right, we'll connect it with that.
Lordship.
Same district even we suppose.
In the meantime, we'll get our instructions, my lord.
All right, counsel for the petition has provided copy of the petition to the government council, Mr. So and so. The controversy involved in this writ petition is identical, add item to the one agitated in PIL number 23/23. Thus, both the writ petitions shall be tagged and listed together after 4 weeks.
Obliged, my lord. Deeply obliged.
Item number 4.
Yes. It's a surface matter. Surface matter, sir, what to do,
Yes,
why?
This is not a service matter, my lord. That property which was mortgage already sold in auctions. And the thing is that already some belongings were there, my personal belongings is around 2 crores. That was under lock and key.
Yes.
That was also auction.
So
we don't
you have
know
to go to the DRT and tell them that there is some irregularity in the auction proceedings. How a writ court can entertain this?
But I have submission, my lord.
Yes,
There's under 13.4, we can challenge that DRT, there's a provisions.
yes,
But if there is a real lacuna in the auction sale.
yes.
But my lord, this is a certain specific circumstance whereby the auction is all right, no problem.
So your properties were lying in the house. Why didn't you remove them before this?
No,
same
no,
was
that's what I'm, this is the thing they have stated that they have already removed and they said they have informed us. They didn't inform us, my lord. They
That
didn't
is
inform us
purely a
anything.
question of facts, sir, disputed questions of facts.
Yes,
How
my
they
lord.
can be gone into the writ petition?
My lord, the person is that they only can go to the Excel, my lord. Regarding the compensation part, because they have already sold. What that-
Compensation, how to establish it is your claim that your goods
Yes,
were
my
lying.
lord,
Have they admitted it?
Yes, they have admitted.
Let us see, read.
Lordship, pass over for the timing, Lordship. Just engage.
All right, pass off with timing.
Item number 5.
May I please? Matters relating to inquiry of custodial death, my lord.
Yes,
Petitioner is the
Mother.
mother of the
yes.
deceased Zakir Hussain, was arrested by the.
Inquiry under section 176 was not held.
My lord.
Inquiry under section 176, was it conducted or not?
No, my lord,
He was in jail.
no information with the petitioner, my lord, whether the investigation has.
Yes, madam, we'll put you to notice,
Yes, my lord.
file a reply, issue notice.
But before that, Lordship, I just want to take lordship to item page number 29
Yes.
and page number 21, lordship.
CRPC.
Uh,
21.
yes, lordship.
Yes.
This is the handwritten, this PM report, lordship. The injury, what they are saying, lordship,
Yes.
the hemorrhage and internal hemorrhage and all these things.
Yes.
No external injury seen on the abdomen on decision. No sign of hemorrhage found on the peritoneal cavity.
Madam, will you have a look at 176, please?
Lordship,
This is mandatory.
lordship.
Pass it on. Holding inquiry under section 176 when a man under custody dies is mandatory. Why have you not conducted that inquiry?
Lordship,
That
I
is for
shall
you.
obtain instruction if that.
All
is
right,
conducted.
issue notice to the respondents. MS so and so appears on behalf of all the respondents. Copy of the petition has been provided to her. She prays for and is granted 2 weeks' time to complete your instructions and file counter affidavit
Lordship.
if so desired. List after 2 weeks.
Obliged.
Lordship. Deeply obliged.
Okay, very good. Yes.
Item number 6,
May it be the lordship. Lordship, can the matter be done for the timing, my lord? My senior, he'll be arguing the case. For the time,
Very well.
lordship.
Last.
item number 33 of supplementary.
May it please, your lordship.
Yes, please.
Lord, there are several irregularities, my lord. Your lordship should first come to my lord. Page number 80, my lord.
Page number 80.
80.
Yes. What is subject matter, sir? Let us know.
Subject matter is, my lord, it's a virtual courtroom in about 1859 schools of the state,
Virtual
classrooms.
classrooms.
Yes.
Okay.
And
Then-
my lord, the most pertinent part is using two-way satellite technology.
Okay.
And the work has been given to respondent number 4, who doesn't have the experience in this. Not only that, my lord, there are so many irregularities. My lord, we could obtain all this information only under Right to Information Act.
Mhm.
That is why, my lord, and moreover, my lord, the financial bid was, my lord, finalized on, my lord, the 30 March.
Yes.
Whereas, my lord, in the website, the order was uploaded only in July.
Okay.
Allocation of order. And my
Have you
lord,
made any representation before approaching the court?
yes, my lord, we have
Let us see.
approached, in fact, central government requested directed the state government to seeking reports. State government never responded, my lord.
Page 320.
Yes, if your lordship would kindly come to page 362, the central government's communication, my lord,
Just one.
362.
There is one at page 320 as well.
Yes, but my lord, 362 makes the position clear, my lord.
Very well.
Please refer to this ministry's labor of event number dated 29/3/22 and subsequent reminders dated 29/4/22 and 25/22. Forwarding that with representation received from Brij Mohan Dodial, that's the petitioner, my lord, regarding wrongful tender allocation to Gumbi under ICT school.
What is the
intervention.
status of the petitioner for this litigation?
My lord?
What is the status of the petitioner? Locus?
Yes, my lord. The petitioner, my lord, similar, the petition he initiated in Uttarakhand, my lord, where, my lord, the authority cancelled the work, my lord.
Okay.
Yes.
Very well.
And, my lord, central government took cognizance of the complaint filed by the petitioner from time to time.
And what about the work has started or not?
Work has started. My lord, some payments have also been made. But what the state government did, my lord, state government took some bank guarantee for the payments released. My lord, it's a work worth 342 crores.
Okay.
I'll just show, my lord, how, my lord.
All right, we'll put them to notice.
Yes, my lord,
Heard.
at this stage.
Issue notice to the respondents. Who would be appearing? Let us know, please. You have for 1, 2, Mr. Your good name, please? V. B. Chaudhary. G. Puts an appearance on behalf of respondent number 2. Number 3 also, we 2 and 3. Mr. R.K. Dev Chaudhary would be appearing for respondent number 1.
I am appearing.
You are appearing.
K. Gogoi, Lordship.
K. Gogoi appears for respondent number 1. Let process be issued to the respondent number 4. Steps to serve such respondent be taken in 3 weeks. Thus the service is permitted.
My lord, may kindly have make the rule notice return.
Returnable in 3 weeks.
Yes. Deep level. And my lord, the only thing is, my lord, if they take any action, that will be subject to the outcome of the.
That is presumed once we have put them to notice.
Much. Very well, very well. Deep level.
Yes.
Item number 8 of daily list for admission.
Yes.
May I please see my lordship?
Yes.
My lordship, we need to file a reply in
We have
respect of.
taken out a judgment, Rajasthan High Court, division bench, Shiv Dayal or something like that. Shambhu Dayal. Justice Arun Mishra's judgment. Right. Shambhu Dayal versus State of Rajasthan. Your matter is covered by a division bench judgment of the Rajasthan High Court, wherein the validity of the same rule was challenged,
My lord.
and it was held that the rule is valid, and ultimately the procedure for applying parole to the convicts under the NDPS Act is to go to the committee prescribed by the central government. That is the only procedure. There is not much in your matter, madam. Earlier also you sought time.
My lordship.
So what is to be done? Let us know.
My lordship, we need to file a reply in respect to the affidavit in opposition filed by the opposite party, my lord.
Okay. Counsel for the petitioner pays for and is granted 4 weeks time to file a rejoinder to the counter affidavit submitted on behalf of the respondents. List after 4 weeks.
Obliged, my lordship.
Item number 9.
May I see your letter?
Yes, please.
My lord, by this appeal,
Please, your lordship. And before my learned senior statsman, I have been newly engaged in the corporation, my lord.
Okay.
Yesterday only I have, the briefs have been handed over. I mean, some time to go through the matter.
You need time.
My lord.
What's your good name, sir?
M. Smith, my lord. M. Smith.
M. Smith. Counsel Mr. M. Smith submits that he has been engaged by the
Yes,
respondent corporation
yes, ma'am.
here recently here and before, and thus he needs some time to complete his instructions and argue the matter.
this matter may kindly be listed in second week of appeal, my
Or we listed in 3rd week,
matter.
list in the 3rd week of April 2023.
Matter.
Item number 11.
Please, your lordship. In this matter, the challenges with regard to the termination of the retail outlet petrol pump, your lordship.
Yes.
Then we are basically challenging that the specific guidelines have not been followed in doing same, your lordship. Basically, there are certain guidelines which specifically this is a case where there is a termination and it is directly, your lordship, hitting his livelihood. So it has to be followed, but that has not been clearly followed, your lordship. There are in fact, in these cases, 3 inspections were done. only in one inspection, the whole issue was there. The other inspection subsequently or prior to that did not find any issues. So that part, your lordship, has and with regard to the inspection by the AAC, your lordship will find that the annexure A at page 58. I'll show your lordship, page 58, annexure A.
Sir, you show us the shortcoming in the single bench order before proceeding to take us through the documents. What is wrong in the single bench order, please?
Lordship,
You are in appeal.
This issue which I am raising with regard
Yes.
to the violation of the provisions
Yes.
have not been considered, your lordship, in the
Were they-
by
were
the
they
honorable
part of
single
the-
judge have
what-
come into a conclusion that I have been duping the
Customers.
customers. But where is there is no complaint from any customers at all.
Need not be. If
The
there is
issue
any additional fitting,
That
found
is
in-
what I'm trying to
Yes.
show, your lordship, that additional
Midco.
fitting, which the court has come to a finding, is in fact not there, your lordship. Because that is why I'm taking your lordship will kindly see page 58 for a moment.
yes,
58 just at the top. This was inspection was on 29/3/2018. Your lordship, last column has seen that
yes,
the inspection. Then the last inspection was on 21/3/2018. These
Yes.
are the two inspections which have held within a period of a week.
yes,
Now your lordship will see they have found page 59
yes,
in the last column. That is G.
Yes.
That is G, your lordship. W and M seal intact. So weight and measure seal is intact. So that is
that
the
doesn't make
seal.
any difference at all. That doesn't make.
That is
we
the
have taken
seal
out that
under
judgment.
which
One more judgment we have taken out on this very issue.
there was
IOC.
another judgment by this honorable court, which
Yes.
is under challenge before the division
No,
bench.
there is a Rajasthan High Court division bench judgment based on a Gujarat High Court judgment. Midco report. Yes,
Midco, yes, that's that another issue, your lordship. Midco personnel has to be there at the point of this.
not at the time of
assessment.
inspection.
And
No,
that
no,
was not there.
not required,
The
not required.
officer of the company was not there.
Very well,
This
you
is
carry on.
mandatory, your lordship.
Yes, this is the judgment, yes. Santa Gracia. Yes, carry on.
That is mandatory, your lordship. This mandatory have not been done. Number one, your lordship, no persons from the Midco was there,
How do you say that it is a mandatory requirement, please?
because that is as per the, your lordship, marketing rules.
Read, please.
That is,
Read.
I'll show your lordship, that is, your lordship will find at marketing rules 5.1.4, additional fittings, your lordship. Any mechanism, fittings, gear fitted in a dispensing unit, which is likely to manipulate the delivery. Additional removal, replacement or manipulation of any part of the dispensing unit, including the mechanism, gear, microprocessor, chip, etc., electronic parts, software will be deemed by tampering of the dispensing unit.
Yes,
In such cases, views and independent opinion of the original
OEM is necessary.
is not there.
He
Would
is
be
not
obtained and
supposed to be there.
suitable decision taken. That has not been
Will
done.
you please hold on? This does not require that the Midco representative should be there at the time of inspection.
Yes.
The report has to be sought from Midco.
That has
That
not
has
been
been done.
sought for, your lordship.
Let us see. Okay.
Let him
Very well.
answer that, so it has not been sought for.
Yes.
Number one. Number two, your lordship. The second part which they have said with regard to
Yes.
weight and measures, your lordship, seal tempered.
Yes.
Seal has not been tempered, your lordship. The tempering has to be that the seal is missing. That is not there.
Yes.
Secondly, your lordship, different seal has been put into the WMN. That is not done. So your lordship, seal is broken. It is not broken. Only
Right.
thing is that a seal has been in a different position. So it was there for 1 year in the particular area. And in that case, your lordship, due to wear and tear, a little bit of this might happen. That is the only.
Additional gear comes to be installed due to wear and tear.
Additional gear is under the WNM seal is intact, your lordship. How can it be installed? And this has been seen from two things, your lordship. The
Yes.
photographs. Even the photographs does not reveal that, your lordship, clearly.
Yes.
Thirdly, your lordship,
Yes. Carry on.
and one thing, your lordship, when the dispensing is there is a less part of dispensing in the unit.
Yes.
Then, your lordship, the termination is not defined.
Yeah, right.
It is 25,000. Your lordship, that is a
Right.
That part
Okay.
I am not on that.
Okay.
These two parts, your lordship, with regard to the termination, these two things, specifically, the Midco representative was not consulted before taking a decision.
Okay.
Number two, your lordship, with regard to the tempering part, nothing has been
Yes.
specifically stated. And this tempering of the hologram is not specific, your lordship, and I have specifically indicated that this has not been done by me.
Very well.
Secondly, your lordship, there was no complaint for anyone from anywhere that there
Not
was some
required.
kind of a dispensation, wrong
Yes.
dispensation or so. So
All right.
therefore, your lordship, without making certain, your lordship, following the rules, this has been done without following that rule. So that is why, your lordship, that is specifically bad.
Yes.
Yes, and secondly, your lordship, the honorable single judge has not gone into those, your lordship, has gone into a different aspect of the matter and held that yes, the court will, is entitled to
Kindly read para 14 of the judgment.
lodge. Lordship, para 14, your lordship. On
Yes.
one hand, your lordship, Ms. Sri Sharma, Learned Counsel representing the respondent corporation has submitted that the inspection in which the double metallic gear has been detected was done on so-and-so. And only about a week before, another inspection was done on which no such anomalies were detected. The corporation council has explained that by installing the, now your lordship, it was not detected. Now the
Please.
council has stated
Please read.
that,
sir.
that by installing the double metallic gear, the flow of fuel by the pipe slows down, which give direct benefit to the pump owner. And in instant case, the same was detected in presence of representative of the petitioner whose signature was taken. And therefore, there is no scope to submit that such inspection was done behind the back of the petition. He further submits that on such detection, the petrol pump seal, the holographic seals were put. However, when the second inspection was carried on 14 to 2019, it was found that even the holographic seals were tempered. No, it
Yes.
was not. I will show the report, your lordship. Though the petitioner has denied any role in such tempering, it is submitted that the attending facts and circumstances would lead to reasonable mind conclude that it is the beneficiary who would indulge in such activities. Now, the first question arises, your lordship, in the second inspection, because the double gear was not found. Only issue was holographic seal. Holographic
Yes.
seal was not in place. It was not tempered with, your lordship. It was not found in place because of the wear and tear for 1 year. This was done after 1 year when the metal was
Yes.
sealed. Then under that circumstances, what happened to the double gear, your lordship, within that
Right.
period, your lordship? That is the issue, your lordship.
Very well.
This is, and they have, in fact, these two, lordship, these two inspections,
Yes.
from the photographs they have made out that there were seals. It is not that they have found the seals. They have taken earlier inspection, took photographs of the that particular gear, and then again another photographs were taken when there was no gear. There's nothing in between, your lordship. And these two and the earlier inspection also. The earlier inspection found everything was in order. The next inspection found that there was a gear, double gear. Then again, the inspection found nothing was there. Only there was a little bit of change in the position of the hologram. It is not
Yes.
tampering with the hologram. These are the reasons. That is why I am pointing it out, your lordship. Your lordship, the second inspection, your lordship will find that is at page 67.
Yes. Sixty-seven is the reply to the explanation.
Sorry, it is the reply. It is at page, sorry, page 72, your lordship,
Yes.
page 72. Subjoined visit so-and-so, your lordship, inspected. Here procedure, your lordship will see in the far below. All the committee's members, here all the members are present. Meteorology also present,
Yes.
technician also present, IOC also present.
Yes.
All the committee members along with legal meteorology inspector Dhubri and micro representative came to the RO, and they have, your lordship, came to the RO at about so and so with the permission from the representative. Plastic cover from the DU was removed on so and so time. Start counting of holographic seal and found 12 numbers of the seals were there. It is not that there is not there. It appears that position of Some of the
Yes.
holographic seal change from the original position and condition of the some of the holographic seal deform from the date of the original putting of the seals on so and so. So it is not tampering. It has been a little bit here and there because this is 1 year after the period.
Right.
And that was lying there in the open for 1 year, your lordship. Now your lordship will see the next page. The joint visit has found current photographs of all holographic seals were taken. Comparing condition of holographic seals as per today's photograph and photograph of so-and-so will clearly state the conditions of abnormality, if any, in the holograph seals. With permission, so-and-so, so-and-so. The
Yes.
holographic seals were removed from the so-and-so. Inside photograph of both the metering assembles were taken. Both the WM seals were found intact. To clear photographs of the assembly, WM seals of both the meeting assembly removed with due written permission of the legal meteorology inspector Dubri. Photograph of both the metering assembly after removing the top cover was taken. Single metallic gear was there in right side meter, looking from the road from the building and photographic, building, photographic, inspection over so-and-so, total reading so-and-so, conclusion. Now the only conclusion they have come is that after comparing the physical copy of the photographs of the current date and the previous date, the final conclusion may be arrived by the appropriate authority.
Right.
Now the appropriate authority came that there is a tampering. Where is the tampering, your lordship? From the report, there is no tampering. It is only changed from the position. It was put in 1 year earlier and it was sealed. Now the seal in 1 year, anything might happen, your lordship. Even the seal might have torn out, but it is not torn. It is still there. But somewhere a little bit of remove here and there, there's a change in position. That's the only problem that has been found. Now, second gear has not been found in the second one. What my learned friend was, what the honorable single judge has said was that it has been done. This is the main committee which is constituted and it has all the representatives which are required. Weights and measures, Metco, everybody is there, your lordship. They did not find anything. And one committee suddenly come up and have a check. And they find these, and that too within a week before another weight and measure committee has come and checked it and found everything was fine.
Yes.
And that too from the photographs, your lordship, only photographs were there. Secondly, your lordship, these photographs were never provided to me. Never provided to me all throughout, so that I can say whether they are correct.
Where is this pleading in the writ petition?
There is a pleading, your lordship.
Right.
I have a pleading in that
Right.
with regard to the.
Have you asked for it in response to the show cause notice? Did you ask for the photographs? You must have responded.
I
If
have
you did not
responded. I
ask,
have
it is
responded,
presumed.
your lordship.
If
All
you did
throughout I
not,
have responded.
if you did not ask, it is presumed that you were having the photographs.
Just that with regard to the photograph, whether I have asked or not, I don't know. But
Don't
with regard
know.
to non
Is not an answer, sir.
stated it in my writ petition.
Let us see.
Mm,
Read your reply to the show cause notice.
lordship. Lordship, page 67 is my reply. Your lordship.
Yes.
This, I will not read the first paragraph. This irregularity of double metallic gear inside so-and-so is evident from the retail outlet inspection dated so-and-so. Prior to this, such inspections was lastly conducted on 24/4/2015 when no such irregularity was detected. On 7/3/2018, in course of servicing of the dispensing pump by the service engineer Gibraltar.
There is nothing in this explanation that photographs were not available.
Because this photograph part came up in the second, your lordship, inspection. Because the first inspection, they have taken the photograph, went away. Then the second inspection took place where they said that the earlier, comparing with the earlier photograph.
Yes.
These photographs were, there was some.
It was there in the show cause notice.
In the hologram scenes.
Gentlemen, double metallic gear
Yes.
was visible in the photographs.
In this photograph, they say it is visible.
Then you said the photographs were not provided.
That
You
those
never
were not
asked,
provided.
you never asked for it in your reply to the show cause notice. Let us see your pleadings in the writ petition.
Lordship.
Even come to page 82. Even in that information which you seek under the RTI, you don't say that you don't have the photographs.
No, RTI have sought for the order of the
If
termination.
you are not having the photographs, you would have immediately spoken out. Yes. Read your writ petition.
Lordship.
And appeal lies. You should have filed the appeal. On that ground also,
Lordship, that's
your writ is not maintainable. If you want, we can give you the liberty to file an appeal. Mr. Counsel,
Lordship.
if you want, we can give your client the liberty to file an appeal. Otherwise, these are disputed questions of facts. Why should we go into these questions and that too at the appellate stage?
That is, your lordship is correct to that point, but the question is whether this had been done or not. That is the.
That should be for the appellate authority to
Just a moment.
consider. We can save your client by observing
Yes.
that any of the findings recorded in the single bench order will not come in way of your client when the appeal is being heard.
By the authorities.
Yes,
That can be done, your lordship. If I am aggrieved by that, then I can always come back.
of course. So what is the option to be excised?
At this stage, I think your lordship's option is a better option to go about. At
Yes,
least
Mr.
I
Counsel,
can
what do you
argue
say?
all the points out there.
Well, there is a provision for appeal.
Yes, they mentioned it at para 23 of the writ petition.
Yes.
So what do you say that we permit them to file the appeal? Otherwise, there's a big flaw in your procedure. Why did you seize the assembly during the first inspection? When you,
First inspection,
yes,
my lord, we have called
you were hands in glove with the dealer. You gave the dealer the opportunity to rectify whatever mischief had been played. Right?
My lord, what has happened when the team of my lord, IOCL has reached, my lord, they had contacted my lord, weight and measure department inspector and manufacturer's, my lord, representative. They were out of station.
So then
That
you
is
should
why
have
holographic seal
you
was-
should have seized the assembly right then and there.
The holographic seals were put.
All right, but then you keep on sleeping, go back after 1 year. Seals are of plastic.
Yes.
They would deteriorate with the effect of time, by efflux of time.
And in fact, as per the my lord provisions, my lord, it is the responsibility of the dealer to keep intact of
For
the
how long?
holographic seal.
For how long? For eons together.
So far period is concerned, there are some lapses on my.
Some,
on-
only
on my-
some.
My lord, it takes some time. my lord.
Immediately on the first inspection, if there was some tampering with assembly, it should have been seized and sent to the OEM. That is a requirement of your guidelines.
Yes,
Why didn't you do that?
it takes.
So
some
we
time.
permit him to file the appeal. And we'll observe that the findings recorded in the single bench order will not prejudice the outcome of the appeal. Okay?
My lord.
This writ appeal is directed against the judgment and order dated 13 December 2022, whereby, writ petition preferred by the petitioner, WPC number so and so, preferred by the petitioner, who was granted a retail outlet at Khudimari, Gauripur, Dhubri, Assam by the respondent IOCL was cancelled,
Terminated.
was terminated. The order of termination dated, annexure so and so dated, so and so was assailed by the petitioner by filing the writ petition, petitioner appellant by filing the writ petition, which came to be dismissed by the order dated 13/12/2022. Being aggrieved, the instant appeal has been preferred. After addressing the court for some time, when counsel representing the appellant candidly conceded that certain disputed questions of facts are apparently required to be agitated by the petitioner appellant for espousing her cause against the order of termination, and as such, he would be better advised to avail the remedy of appeal as provided under the guidelines,
Lordship.
Yes, my lord.
marketing discipline guidelines.
Yes, my lord.
He thus prays that the appellant may be given liberty to
8.9.2.
8.9.2
My lord.
under clause so and so of the guidelines. Appellant may be permitted to approach the appellate authority, and that the appellate authority may be directed to consider the appeal of the appellant on merits without being prejudiced by the findings recorded in the impugned order dated so and so. So this submission, then counsel, Mr. So and so, representing the respondent corporation, does not have any objection. Accordingly, the appellant is given liberty to move an appeal to the competent authority under clause so and so of the guidelines for assailing the termination order in annexure so and so dated so and so. If the appeal is presented within next 30 days, the same shall be treated to be presented within next 30 days along with the mandatory pre-deposit, the same shall be treated to be within limitation and will be considered and decided on merits without being prejudiced by the observations made in the order dated so and so passed by learned single bench. With the above observations, the appeal is disposed of.
Appellate authority is my lord executive director.
Executive Director.
Much obliged.
Matter number 14.
That is lost.
Yes.
Fine, in this case, my lord, as per order of the honorable court lordship, the social welfare, my lord, director of social welfare, my lord, conducted inquiry lordship and my lord found that and held, my lord, that I am, my lord, outsider, the respondent number 6 is, my lord, insider lordship. My lord, that order was put into silence lordship, the learned singles of my lord, relied upon a report, my lord, kindly be seen, page 117.
Local woman.
Yes.
Yes.
My lord. My lord, the report, page 117, my lord.
Yes.
That report was prepared by the, my lord, circle officer, my lord. Actually, the deputy commissioner was directed to, my lord, submit report, my lord. The deputy commissioner, my lord, without personal inquiry, my lord, personal verification, my lord, delegated the circle officer, my lord. The circle officer, my lord, also, my lord, did not make any verification, my lord, relied upon the report submitted by the, my lord, CDPU, lordship.
Yes.
CDPU, my lord, my lord, the, my lord, and other, my lord, law, my lord, gas
So
level.
these are
authorities
questions
my
of facts, brother. Questions of facts.
lord. Yes, lord.
Writ court has already considered this report.
Yes,
Now
that
are we supposed to go
My lord.
behind?
That is considered, my lord. Now
Then-
kindly be seen, lordship, whether the report relied upon by the learned single judge lordship,
Yes.
that was, my lord, authenticated or not, my lord. Now kindly be seen the page 114, my lord.
Yes.
The highest authority of the district of the department, my lord, submitted a report after proper field verification, lordship.
Yes.
My lord, page 114, first report 1, lordship,
Yes.
my lord.
Yes.
With reference to the subject cited above, I have the honor to inform you that I have physically visited the locality of Sangazan Goromari AWC area as well as the residential area of both the petitioner and the respondent under Roha ICDS project. And my findings in this regard are given below. The residential location of the petitioner, Mosamad so-and-so, is within the area covered by the Sangazan Goromari Anganwadi Center. Her residence is around 150 meters away from the AWC. The
Yes.
residence of the respondent number, Mosamad so-and-so, is far away from the Sangazan Goremari AWC area. Her residence area is covered by Sangazan AWC under Kapili ICDS projects. As per my physical verification and according to the statement of the local people, it is found that the petitioner, Mosamad Jinnatara Begum, is a local candidate and respondent Mosamad so-and-so is an outsider for the AWC. My lord, this report, my lord, was not relied upon. Then, my lord, another, my lord, she was, my lord, the district social welfare officer, highest authority of the district lordship of the
Yes.
department. Next page, lordship, kindly be seen, my lord.
Mm.
He was given authority to, my lord, again re-verify lordship. My lord.
And in that
page
interview,
15,
it
lordship.
don't,
I was found inside our lordship, again.
no, no, again, she did not appear. She did not even appear for verification.
My lord, in the interview lordship.
Yes.
My lord, because I was not called for lordship. I was not called for interview, my lord, two candidates were there, my lord, the respondent number Sikhs and me, lordship.
Yes.
I was not called for because of that, my lord. I was not able to appear.
How do you
in
say
the-
that you were not called? Let us see. From where did we get it that you were not
My lord, I have stated.
intimated to appear in the interview?
I have stated, my lord, page 39, my lord, paragraph 2 can be seen.
39.
Yes, lordship. My lord, bottom. Paragraph 2, lordship. Bottom sentence, lordship. It is pertinent to mention herein that for the post of worker in the said center to SSLC past candidates residing in the sorry, lordship. Being aspirant for the job of worker in Sengazan Goromeri Anganwadi Center under Roha ICDS project, the petitioner filled up the application in the prescribed format, but she was not called for to appear before the selection committee in the plea that she read up to class 9.
Yes.
My lord, on that ground, she was not called for, my lord. The fact is, lordship, the criteria is, lordship. My lord, the educational qualification is SSLC passed, lordship. In the event of any dart of candidate, lordship, class 9 pass, my lord, was fixed, lordship. I was my class 9 pass, lordship. But the respondent number 6 was, my lord, SSLC, my lord. But she was outsider, my lord. She was alone called for, lordship. That is why I was not able to appear before the selection committee, lordship. Now the selection member of the selection committee was the secretary was the CDU and chairman was the circle officer, my lord. The report submitted by the circle officer on the basis of report prepared by the circle, my lord, CDPO, secretary, lordship of the selection committee, lordship, my lord, was relied upon, lordship. But the report submitted by the higher authorities, two reports, 2 times on field verification report.
Yes.
My lord, circle officer did not make any field verification, lordship. My lord, that report was, my lord, relied upon. The report of the district social welfare was not. 2 reports were not relied upon, lordship. My lord, if the report was, my lord, not relied upon, that was not rejected, lordship. No findings, my lord, is there as regards that, my lord. This is highly arbitrary, lordship. In my humble submission, it may be re-verify, my lord, the case may be impaired and specific finding. may be
Almost
given.
12 years, 13 years since the selection was made.
Anyway, my lord, I am, my lord, lagging before this honorable court, lordship. My lord,
Now, read para 9. There's a fresh report called for by this court.
my lord,
Read para 9.
judgment, lordship.
Yes.
Lordship.
Yes.
It further reveals that the survey report submitted by the CDBU was contrary with the report submitted by the district social welfare officer dated 27/2012. Accordingly, both the officials were directed to attend the directorate to discuss about the matter on 17/5/2013. The district social welfare officer thereupon decided to re-verify the matter and to submit a fresh report. Accordingly, the district social welfare officer on 21/5/2013 had submitted a report. In terms with the said report, the residence of the respondent number 6 is at Sengazan Goromari area and nearer to the concerned AWC. It was further informed that the residential location of the petitioner is within the concerned AWC area, but as per the local records of the circle of supervisor, it was found that the petitioner did not appear in the interview for the post. My lord, because of I was not called for, I was
Yes.
not able to, my lord,
I
appear,
understand.
lordship.
Thank you.
My lord.
Okay, very well. Anything else to say?
My lord,
Yes.
my lord,
Who's representing the respondents?
No.
Yes, please.
But we are relying on the report of the affidavit of the director, case number 108.
Yes. 108. Yes. This is affidavit.
Yes, Lord, the affidavit.
Yes. Director Social Welfare. Yes.
Paragraph 4.
Okay, very well. I think all right. Dismissed.
My lord, one submission may I made, my lord. My lord, if you lordship find it is, my lord, I may be given liberty to file, approach the my civil court lordship.
Dismiss, sir. Let it be laid to rest finally. Thank you.
Liberty lordship.
No liberty, sir. You already had 3 rounds of litigation, enough. Okay.
Or like that.
Matter number 15 and 16.
Before the learned senior counsel submits, so there are connected writ appeals which are yet to be numbered against the same judgment. and
Same
order.
judgment.
No,
They have to be. What about 44? Writ appeal number 44? That is not listed
Yes.
today.
Yes.
44 is item 16.
It's already listed.
Yes.
So
Yes.
there are more appeals.
yes, there are more appeals.
Okay.
I can provide the serial numbers of the filing serial numbers. Delay was condoned on 24th of February. There are
Okay.
2 appeals which I.
MS so and so. It's okay, sir. If we direct the appeals to be connected,
My lord.
MS so and so submits that similar appeals by other writ petitioners have been filed arising out of the very same impugned judgment dated so and so passed by learned single bench, and that these appeals are yet to be numbered. First up, it is further stated that delay occasion in filing of these appeals has also been condoned. In view of the submission noted above, registry is directed to number the appeals referred to above and list the same with these 2 appeals after 3 weeks.
My lord, may I pray for a fixed date subject to convenience of the lawsuit?
Maybe we can have it on 19th April.
My lord.
19th April.
My-
After 4 weeks. List the same on 19th April. Yes.
Awesome.
Matter number 17.
May it please your lordship. This appeal is against the rejection of a primary contention that a retired bank official is incompetent to act as an inquiry officer under the scheme of UCO Bank Officer Employees Discipline and Appeal Regulation 1976.
Okay.
Now, this regulation 6(2), my lord, it gives a discretion to the inquiry authority, either to inquire himself to the imputation of misconduct
Or appoint
or
any
appoint
public servant.
other public servant.
Right.
Now, the question is whether a retired person will come within the term of public servant.
Yes.
Now, regulation 3(and), my lord, defines the public servant.
Let's
To
read.
mean, yes, to mean, my lord, a public servant as defined under section 21 of the IPC.
Okay.
Your lordship may kindly take up IPC now.
Yes. Yes, please.
Section 21, my lord, defines public servant.
Yes.
May I read, my lord. The words public servant denote a person falling under any of the description herein after following, namely so and so. There are 12 descriptions.
Yes.
We find. So a person who doesn't come within this description is not considered to be a public servant.
Yes.
And our contention was the retired bank employee, my lord, he doesn't answer any of this 12th contention, this 12th description. A retired bank employee is not comprehended in any of these 12.
Yes.
Now that was rejected, my lord. And honorable single judge invoked, my lord, clause 6. Lordship,
Of
can you see clause 6?
The regulations,
Oh, no, my lord, 21.
21.
20.
Okay.
Now, Lordship will find it. This description 6, Lordship will find.
Yes, yes.
Every arbitrator or other person to whom any cause or matter has been referred for decision or report by any court of justice or by any other competent public authority. Now, the finding of the honorable single judge is, my lord, that the retired public servant, retired bank official, by virtue of being other person, he will be a public servant.
Yes.
And for arriving at that conclusion, my lord, the honorable single judge entirely relied on, my lord, Alok Kumar's case.
Yes.
That is, my lord, 2010 5 SCC 349.
CRPC. Yes.
2010 5 SCC 349.
Yes.
My lord, my contention is the reliance is absolutely, my lord, misplaced.
Mhm.
In Alok Kumar's, my lord, Supreme Court was called upon to interpret the word other authority,
Yes.
appearing in Rule 9(2) of Railway Servant Discipline and Appeal Rules 1968.
Yes.
And the conclusion of the Honorable Supreme Court was
Yes.
that in Rule 9(2), there is no intent of the legislature to give it
Yes.
a restricted or narrow meaning. It is a broad meaning,
Yes.
and the conclusion is the other authority will include a retired.
Please
Private
read
railway
section 197 of the CRPC in conjunction with section 21.
My lord.
197 CRPC in conjunction with section 21.
Prosecution of judges and public servants. Whenever any person who is or
Is or was.
was a judge,
So for the purposes of these two codes, even a retired public servant continues to be a public servant. If a retired public servant is thought to be prosecuted, sanction is sine qua non. There is the test. So you want our opinion on it? It is writ large on the face of the record by the codes.
my lord, this regulation refers to 21.
Yes. Without referring to section 197. You want to make research on it? You can.
My lord,
Buddhi Kota Subbarao is the leading judgment.
my lord,
You can read the judgment.
But Dr. May kindly give me some time, I will come back.
Yes, sure.
I will come back.
Council petition place for time. Please up to 2 weeks. Appellant place for time.
Letter number 18.
Is or was. Yes,
Let me please your lordship. This is against the order of termination of service of the petition.
yes,
Your lordship, the impugned judgment of the honorable single judge is at page 29.
yes,
Lordship, basically, the issue is that the petitioner has lended money, routed in fact money from various accounts, his accounts to other accounts. And
Yes.
there was some shortfall of money in certain accounts of the, your lordship, customers, your lordship. That was the issue, your lordship. There was he was terminated and the forfeiture of his, full forfeiture of his gratuity the Honorable Court interfered with full forfeiture of the gratuity and directed that only the part which has been misappropriated or the part that has to be taken other return. And
yes.
with regard to the termination, it was not interfered with.
Yes.
Basically, Your Lordship, my first case is, Your Lordship, with regard to the fact that there were some complaints that they have issued a charge sheet saying that there were some complaints by persons where some amount of money has not been given to them on loan, Your Lordship.
Yes.
The loan amount has been sanctioned to be X and it was given, Y was given to them. So, Your Lordship, that part itself, Your Lordship, I'll show at page 81, Your Lordship, the charge sheet. I'll just take, Your Lordship, to the charge sheet because the charges are and the inquiry, Your Lordship, has two different aspects. That's why I'm showing it here.
Yes.
81, Your Lordship, for a moment. This is the charge sheet, Your Lordship. Now, 1A, I'll read that. I'll not read all. I'll just read a few that will
Page
be
81, you are referring.
Page 81, Your Lordship.
Yes.
Here at 1A, Your Lordship.
Yes.
Using your own user so and so, you have allegedly, that is my account, Your Lordship. You have allegedly credited amounts in saving bank account in the name of Sri Nogen Goswami, maintained at Guwahati branch, sitting at Kumargaon. This is a small branch, Your Lordship, Kumargaon branch in a village, Your Lordship. You also raised debits in this account on numerous occasions without any mandate from Sri Goswami, the customer, Your Lordship. This is one of the allegations. I will not read all, Your Lordship. Lordship can go through the next two points. That is at serial number 1, 2, and 3, so that it will be explained in that way.
Yes.
Amounts have been debited from savings account, so and so recurring deposits account and loan account of bank's customer without mandate and credited to this account. Subsequently, this account was debited to close loan accounts and again without any mandate from Goswami, the non-home customer.
Yes.
Branch fixed assets, furniture, fixtures, so and so, was debited with a sum of 90,000 and this account was credited. No entry in so and so was made. So it was credited and debited, but it was not there in the Your Lordship, it was not given in the that particular entry was not made. Then Your Lordship, page 82.
Yes.
B, C, D, E, F. All these Your Lordship has seen. There in B, there was a sum deposit of 75,000 in the account of Bonester Borough. Then it was alleged to have been misappropriated, but later on it was stated, later on when the account holder lodged a complaint and brought the matter to the notice of the bank, you made good the amount on so and so. So this amount was again returned back. That is the allegation. Then comes the next one. There was a loan of 42,000. 40,000 was given. 2,000 was credited.
Yes, sir. What is the scope of a writ appeal? You are arguing a writ appeal. First, point out the lacuna in the single bench judgment. We are not looking at the evidence right now.
First thing, Your Lordship.
Yes.
These persons who has been named and complaints are given, they are not even examined in.
Yes. Yes.
That was
these are all documents maintained in the due course of transactions of the bank. They were proved by the bank manager.
No, that was
W1.
Yes, the witness.
He appeared in evidence.
Yeah, I appeared. There was they have given, Your Lordship, the names of two persons. That is at page 91 for a moment, Your Lordship.
Yes.
What are the documents, Your
will you please address the court on what is the lacuna in the single bench judgment? You are arguing an appeal. Straight off, you start taking us to the evidence. We are not appreciating the evidence in a criminal appeal, sir.
I'm trying to point out that these are the
Read
lacunas which the honorable single judge has not
read
taken
the judgment
into
first, then refer to your
honorable
whatever.
single judge has not taken those into considerations because even if Your Lordship taking into consideration the documents that has been exhibited, there is a misappropriation of at best 37,000 rupees, not beyond that. That is why I'm trying to show.
Even if
that is what I'm trying to
misappropriates a single penny, single paisa, but he is not entitled to continuing service.
That is also disputed on the fact that what they have put at page 91, kindly see.
We are not looking at your evidence, Mr. Counsel. You point out the lacuna from the single bench judgment, then only we'll proceed to hear you.
Lacuna
is the third time we are pointed out.
Okay, Your Lordship will then kindly take up the judgment.
Yes, please.
That is at page 29.
Yes.
There were the para 7, your lordship, what was
Yes.
my uh, what I have pointed out before the honorable court, there were 2 points. One is that I was acquitted in the criminal case. And
Yes.
second was that the dismissal of service is disproportionate, and it should have been in compulsory retirement. These are the 2 allegations.
So
made.
these are the only 2 arguments.
2 arguments.
You
made
don't
in-
question
before
the findings of the inquiry report.
Yes.
You
that
are
no,
arguing only on the question of quantum of punishment.
10, para 10,
Yes,
page 35.
yes,
Insofar as the proceeding before the disciplinary authority is concerned, it is
Yes.
seen from the minutes of the hearing of disciplinary proceeding, Helen Suento, that after the prosecution in chief of the prosecution witness was over, the petitioner was given opportunity to cross-examine the witness, and the sole witness examined by the prosecution was cross-examined. Now, the
yes.
sole witness, there were 2 witnesses. Secondly, the complainants were not witnesses before the court, before the inquiry, your lordship. So the sole witness was also not named as a witness in the list of witnesses, your lordship. The documents that were produced were not listed in the list of documents. These were not there. Now, the question is, under that circumstances, how am I going to disprove my facts here? That is the
Will you
question.
continue to read this para, please?
Yes. In this regard, it is further seen that in the appeal preferred by the petitioner, the order of the appointing authority has not been assailed on the ground that opportunity to examine the documents or opportunity to cross-examine the prosecution witness was not
Provided, should be provided. Corrected is the wrong, is an error.
corrected. Maybe.
Yes,
It is also observed that no other procedural lapses which might vitiate the proceeding before the inquiry officer or the appointing authority has been urged.
okay.
Yes.
Then,
Then your
now what do you
lordship,
have to say?
then your lordship will see the court has come to a finding that with regard to para 1337, in respect of the findings of the inquiry officer, it is seen from the written submission made in the statement of defense submitted in connection with the inquiry cum findings report, which is submitted by the petitioner and so and so. The petitioner is found to have accepted the
Oh,
credit of certain.
It was a case of admission, gentlemen.
That was. No, that was admission with regard to the fact that
With a certain
sum
kind of
money from
justification.
time to time has been, it is from my account, not from somebody else's account. I was operating all the accounts together, your lordship. That is
Read-
the fact.
Read internal page number 9 of the judgment from the top.
Internal 9.
Yes,
Bank account of the daughter of the petitioner bearing bank account number so and so, by and large, the defense of the petitioner is that the said customers were in need of money and had taken loan from the petitioner, which was repaid by the borrowers, and therefore there was no complaints by any of the account holders.
yes,
With regard to all these 12 allegations, there are contained in article of charges. The inquiry officer was of the opinion that the defense by the petitioner was not acceptable and was an effort of the petitioner to cover up. It is in this connection, the submission of the learned counsel for the petitioner is that the transaction were made at the behest of the borrowers, and therefore there were no complaint. And in absence of any complaints, and because of non-examination of any of the bank customers, no case of misappropriation was made up.
para
So
13.
this is basically what
Para
I tried
13,
to say.
please.
This is what I'm trying to say.
Para 13, please.
Para.
13 of the judgment.
In this regard, in respect to the findings of the inquiry officer, it is seen from the written submission made in the statement of defense submitted in connection with the inquiry cum findings report, which was submitted by the petitioner and so and so. The petitioner is found to have accepted the credit of certain sum of money from time to time into the account of his daughter. Therefore, it is apparent that the customer's account, the entire loan money was not credited to their account, but a small portion of money out of the sanctioned loan was credited to the account of the family member. This is the allegation. This has not been disputed. But the question is this, the earlier paragraph speaks of what has been stated here.
Very well.
The amount that was taken from the petitioner by the loaners were returned back. They did not make any complaint because that was subsequently returned back. Some amount was put in the account of the family member, but it was later on refunded. So there was no complaint. This is the basic issue.
Okay.
That is the issue. So what the findings was there, the bank did not say that we have lost
Yes.
so much of amount. They said, but they could not substantiate that in their
Yes,
proceedings. These were pointed out, your lordship.
Yes,
The court did not go into each and every charge because all the charges are on the same nature.
Very
One,
well.
that is why I appointed one person, that particular Goswami, whose account was taken care of all throughout. That person was also not before this court, before the inquiry. Secondly, your lordship, the one aspect of the matter here is that if the persons who has made a complaint or who has some amounts has been disputed here and there, if those are not there, how am I, and your lordship, the documents that your lordship pointed out, all screenshots. These are not documents, they were
Very well.
screenshots.
yes,
It is in the inquiry itself, it has been stated that these are screenshots of the documents.
right,
So
Okay.
under that circumstances, what your lordship, I will be able to do?
very well.
Let us take it in a court of law. How am I supposed, if the evidences are not there, how I can?
This is not a
dispute?
criminal trial, sir.
That
this
is
is a
why
disciplinary
these
inquiry.
facts were not taken care of by the honorable Singh.
Very well.
This is why it has come before your lordship.
Okay. Very well. Arguments heard, order reserved.
Much older.
Matter number 19.
That please, Lordship.
Yes.
Matter regarding preferential appointment method under the provision of a Assam Public Service, Assam Public Service Preferential Appointment Rules 1999.
Yes.
And the petitioner father injured in the year 1983 method. And
Yes.
victim families method, more or less method, more than 500 similarly situated candidates are appointed, but I am deprived and subsequently when the list was prepared that 310
Yes.
students are left over method. Annexure 8, page 35, it is revealed that, but Honorable Single Judge method, on the very date method, she was counted that on the date she was aged about 12 years. As because method that list was prepared in the year 2002. 2001 method, but the list was prepared in the year 2020 method,
Mm.
and 1920. At the time of my 1920, I am 33 years old method. So,
Yes.
in order is method, annexure 16.
Sir, what is the material to support your allegation that
method,
the petitioner's father was a victim of those
method?
events? Please, let us see. Any evidence to that effect?
Kindly see page 22, my lord, annexure 4.
Yes, please. 22. Yes,
May I read, ma'am?
Yes.
It is to certify that Sri Pulin Chandra Borkototi of village Mohmake Malki, Gaon, post office Bokakhat, yes, Bokakhat district, Golaghat, Assam, was victim in connection with his participation in the Assam movement on the problem of
this certificate issued in the year 2018 for an event which took place 30 years back. What is the veracity of this certificate?
Madam, I was when I was measurement of at that time I was filed.
We are
for
asking you,
preferential
sir,
appointment.
what is the contemporaneous record of that time? Any injury report, any postmortem report, any FIR?
No, if I
30 years down the line, you get a certificate and say that I am entitled to job. That doesn't happen, sir.
Like that, my lord, that was approved by the circle officer, my lord, as well as the Latmandal of that locality. Then and on the basis of the report of the circle officer and Latmandal, my lord, the deputy commissioner concerned.
Yes, read the rules. This certificate simply says that he was a victim. Victim in what sense? The rules say that there should be a disability suffered in that incident. The certificate doesn't say so. Is it right?
My lord, the deputy commissioner, on the basis of the deputy commissioner, it should be considered, my lord, because my lord, that will.
What has he said, sir? Is it, does
the
the certificate, even if it is assuming we overlook the fact that the certificate is issued, say 30 years after the incident, does it any place indicate that the man suffered any disability within the meaning of the rules of 1999.
Rules 2A of the.
Yes, read please. Martyr. So he was not a martyr. Certificate doesn't say.
Martyrs are victim of the family, madam. That was revealed, madam. Kindly see impugn order page 96, madam.
Yes.
Sorry, madam, 97, madam.
Rules 1999 provide that if an affected candidate is found to be a member of the family of a martyr or a disabled person,
Madam.
satisfy us that your father was a martyr or a disabled person because of disability suffered in the incident.
Martyr or disablement or bullet injury, they.
So let us see any document to that effect.
Madam, kindly fix another.
Oh, sir, sorry.
Madam,
After arguing the matter for some time,
Madam,
we are not adjourning. No,
unable to broadcast.
absolutely no, sir. This is a record of the writ petition. Please point it out from there.
So, madam, kindly see.
Yes.
Impugn order page, annexure 16, page 92, madam.
92. All right.
Onwards, madam.
Yes.
I'm reading in page 93, madam.
Yes, please.
The petitioner counsel submitted that the petitioner's father, Sri Pulim Chandra Borkoti, was injured during the Assam movement, and accordingly, the petitioner is entitled to get the given the preferential appointment when a recruitment is made to a government post in terms of Rule 4 of the Assam Public Service Preferential Appointment Rules 1999.
Yes.
Hereinafter preferred to as the 99 rules. The petitioner's counsel submits that the office of the Deputy Commissioner Golaghat has issued a certificate dated 6/3/2018 stating that the petitioner's father was a victim in connection with his participation in the Assam movement on the problems of foreigners. Ms. S. Borua, learned counsel for all the respondents, admits that there is no medical certificate annexed to the petition to show that the petitioner's father is a victim of a Assam movement or that he suffered any physical disability in the Assam movement. He also submits that the genuineness of the certificates issued by the authorities which are annexed to the writ petition would have to be verified by the respondents. Besides the petitioner requiring to have all the eligibility criteria required for being considered for government post. In terms of 1999 rules, my lord. On hearing, the learned counsel for the parties disposes of that this writ petition can be disposed of at the motion says itself. My lord.
Yes.
A reading of the provisions of 1999 rules provides that an affected candidate who is otherwise eligible under the normal rules shall be given preferences in making appointments to post under the government of Assam recruitment to which are made through the Assam Public Service Commission or otherwise than through the Assam Public Service Commission. The 99 rules also provides that if an affected candidate is found to be a member of a family of a martyr or a disabled person, the said person can be considered for appointment against the government post in terms of 1999 rules. Section 2A of the 1999 rules defines affected candidate to mean a candidate who is a member of the family of a martyr or member of a family of the person who has been rendered physically disabled and possesses a certificate to that effect issued by the Deputy Commissioner of the respective district in such form as the specified in the schedule to these rules. Section 2F of the 1999 rules defines physical disabled to mean a person disabled in any major part of his body, leading to total disablement in connection with Assam movement on the problem of foreigners. The petitioner claims to be a daughter of the Fishery Pulim Chandra Borkoti, who is physically disabled due to an injury during the Assam movement. The certificate issued by the Office of the Deputy Commissioner Golaghat, Assam State as follows. To whom it be concerned, this is certified that Sri Pulim Chandra Borkoti village, Maiki Gaon, PO Bokakhat, PS Bokakhat district Golaghat, Assam was victim in connected with his participation in the Assam movement on the problem of foreigners and his or family member are as follows. Name of the members and relations, Ms. Ishani Borkatogi, daughter, and Ishankur Borkagoti, son. This certificate is issued on the basis of the report of the circle officer, Bokakhat Revenue Circle, Hyde, memo number so and so, dated Golaghat 6/2018. On the other hand, section 2A of the 99 rules requires that the certificate to be issued by the deputy commissioner has to be terms of the schedule to 99 rules, which states as follows. To a affected candidate means a candidate who is a member of the family of a martyr or a member of family of the person who has been rendered physically disabled and possesses a certificate to that effect issued by the deputy commissioner of the respective district in such forms as specified in the schedule of this rule. My lord, under this provision, my lord, file this instant petition, my lord, and
Yes, please.
only on the basis of the age, my lord, my petition was dismissed. Then the list was prepared in the year 2001. But
Sir, read your application, annexure 10.
my lord. But the list was prepared in the year 2020, my lord. And
Sir, will you read your application, annexure 10, page 37? Is it mentioned in the application that your father was either disabled or was a martyr in the moment?
37. My lord, in the representation only placed for appointment under the provision of this 99 rules to the.
The appointment can only be offered to a person whose relative has been either martyred or disabled in the moment. Your application doesn't say so.
Not only victims, my lord, it is a prayer for appointment of the family members of victim of Assam movement, my lord.
Victim, not every victim is entitled, sir. There has to be a disability or a martyr.
My lord,
Thank you.
Only because of my lord, more or less more than 500 candidates similar.
All right, sir. Thank you.
My lord. But rest, my lord, 300, more than 300 candidates are left over. 310.
Obviously, those who are not entitled will not be given the appointment. Thank you. Dismissed.
Matter number 20.
May please. Yes, in this, my lord, the challenge in the repetition was to the decision-making process leading to award of a contract to the private respondent. And the honorable single judge, without going into the merits, has been pleased to non-suit me on the ground that the repetition is not maintainable. My contention before the honorable single judge was that the tender itself permitted participation as a consortium, and the tender clauses themselves made it very clear that it is the lead partner who will act all through. And the second contention was that there is a fundamental difference between a joint venture and a consortium. Unlike in a joint venture, as has been held by the Apex Court in the case of New Horizons, that it becomes a separate legal entity. In case of a consortium, they can act independently. And that was the contention. That part of the contention has been accepted by the honorable single judge.
Right.
However, in the later part, the honorable single judge has relied on a judgment pertaining to joint venture and dismissed the my lord. May I straight away place the impugned judgment? That will, that by itself will make the position very clear.
Please.
If your lordship will have the impugned judgment, it is in the volume 1. It has run into several volumes. That if your lordship will kindly take up the first volume, the impugned judgment is at page 104.
Yes. Paragraph.
First, if your lordship kindly comes to para 23.
Okay.
This is where my contention has been accepted by the honorable single judge. Para 23 at page 128.
Yes.
In all the above definitions, as well as the observations made by the Supreme Court in various judgments, one aspect is clear, that sharing of a profit is one of the preconditions to hold that the said combination of persons, natural or juristic, to be a joint venture. The Supreme Court in the case of so-and-so, while considering the concept of a joint venture by taking into consideration the various definitions as well as the observations made by the Supreme Court in New Horizons, had given an illustration in paragraph 25, thereby explaining the concept of joint venture. Then the judgment is extracted. Now, if your lordship will kindly come to the para 25, madam.
Yes.
This is where the conclusion with regard to the difference between consortium and joint venture is arrived at. In the backdrop of the above, let this court now consider as to what is a consortium of bidders. The term consortium literally means companionship. However, when used in a commercial context, it would mean a group of shipping lines or a group of companies or an association of several commercial enterprises, or for that matter, joining of several parties to one action. Therefore, a consortium of bidders would also come within the ambit of a joint venture, provided it satisfies the requirement as is necessary to constitute a joint venture, which, as already observed here and above, involves factors such as contribution of the parties of money, effort, knowledge, and other assets to common undertaking, joint property interest in the subject matter of the venture, right of mutual control of management of the enterprise, expectation of profit, and right to participate in the profit. This sentence is very important. As already observed, sharing of profits in a particular ratio is one of the most essential requirements for distinguishing a consortium of bidders from a joint venture. Now, the conclusion in regard to this particular case is arrived at paragraph 37.
Yes.
Para 37. In the backdrop of the above, it is clear that the bid submitted by the petitioner number 1 and pro forma respondents number 7 as a consortium is not a bid as a joint venture, and it is merely a bid as a consortium of bidders. This is the conclusive finding.
Yes.
Now, my lord, at para 39, having arrived at this finding, the Honorable Single Judge now relies on a judgment exclusively pertaining to joint venture. And based on that, my lord, I have been non-suited. If your lordship kindly comes to para 39.
Yes.
The natural corollary to the above is that the petitioner number 1 alone does not have a legal right to challenge the tender process, the tender conditions, as well as the award of the contract. At the cost of repetition, it is reiterated that the petitioner number 1, along with the pro forma respondent number 7, can only be regarded as a bidder. Under such circumstances, the petitioner number 1 alone cannot be a person aggrieved to maintain the present petition. At this stage, this court finds it relevant to take note of the judgment of this court rendered in the case of so-and-so versus so-and-so, reported in 2022 1 GLR 715. In the said case, this sentence again is very important.
Yes.
One of the constituents of a joint venture, but not the joint venture, filed a writ petition challenging the allotment of the contract. Here, the challenge itself was by a joint venture, not a consortium. Now, if your lordship will kindly come, that portion, relevant portion is extracted. If your lordship will kindly come to that, paragraph 40 of that judgment is quoted.
Yes.
A preliminary objection was raised by Mr. Das, learned senior counsel, for the respondent number 5 in respect of locus standi of the petitioner to file the writ petition, challenging the tender evaluation process, wherein the petitioner was not the participant as a single entity, rather it participated as a joint venture along with Messrs. So-and-so. On the perusal of the writ petition, it is found that the petitioner number 1, Messrs. Marilyn, etc., a limited company and lead partner in Ananda joint venture, it is stated in the writ petition that the petitioner number 1 authorized the petitioner number 2, the executive officer, to represent the company petitioner number 1. I have perused the joint venture agreement. Your lordship will kindly note this one. Here, the issue was the joint venture agreement. And I'll place the consortium agreement in this instant case, my lord. It itself mentions that it is an irrevocable agreement. I have perused the joint venture agreement of the petitioner number 1 and the other constituent Messrs. So-and-so, which is enclosed to the writ petition. And therein, under the heading validity of said agreement, it is stipulated that the joint venture shall be automatically terminated in case the contract in terms of the said tender was not awarded. From the affidavit in opposition by the respondent number 5, it is seen that by letter dated so-and-so, it was notified to the said respondent number 5 that its bid dated so-and-so for execution of the work under the said notice inviting bid dated 29/5/2020 was accepted by respondent so-and-so. In terms of the said letter dated so-and-so and pursuant to the signing of the contract, notice to proceed with the work was issued to the respondent number 5. Now, if we consider the validity of the joint venture agreement entered into by the petitioner with its other constituent measures so-and-so, the said joint venture agreement on the basis of which a jural relationship developed between the petitioner number 1 and the other constituent of the joint venture came to an end automatically after awarding of the contract to the respondent number 5. Based on this, my lord, I've been non-suited. Although the Honorable Single Judge at para 37 has conclusively held that there is a fundamental difference between a consortium and a joint venture. May I straightaway place the clause I was referring to in the agreement between the consortium partners? That, unfortunately, my lord, I'll have to trouble your lordship with a different volume. Your lordship will kindly excuse me for that, my lord.
These files could have been presented in a soft copy. These files could have been presented in form of a soft copy. It would have made things easier.
If your lordship so desires, I can.
We are planning to go full steam ahead on this aspect. Just give it a little time. That change is about to set in.
My lord.
All right.
In fact, that system had developed in our High Court during the COVID period. It makes things easier.
Because filings, at least by the government, in the hard copy is not acceptable in view of the Supreme Court directions. It has to be mandatorily in soft copy form. Yes.
This type of cases, soft copy is required. Well, each
bulk.
time your lordship has to look into the
No,
volumes.
Not even us,
Yeah. No,
councils
no,
also.
us also.
and a wastage of paper,
My lord.
all the same. Which volume?
This is in volume 5.
Volume 5.
Actually, under the High Court rules, we are required to file the entire set of pleadings before the learned single judge. That's how it has become so voluminous.
Yes. Volume 5, page number?
1679.
Yes.
Your lordship will, at 1679, your lordship will find the memorandum of understanding between the two consortium partners. This is between, it was signed on 14th day of July 2021. It's between Prism Logistics Private Limited. And it goes on to say, so-and-so having its registered office at so-and-so, hereinafter referred to as leader of the consortium. Next, the other party to the consortium is at page 1681. Your lordship will find the name, which we have arrayed as pro forma respondent in the writ petition.
Right.
It is all cargo logistics. Now, if your lordship kindly comes to clause 3,
right,
towards the bottom of the page,
Mm.
we, the consortium member, hereby agree that Messrs. Prism Logistics, that is the appellant before your lordship, shall act as the leader of the consortium who shall have authority to bind each of the consortium partners. Now, if your lordship will kindly turn to page 1683.
Yes.
There are 3 clauses which are important. Clause 6, any correspondence exchanged with the leader of the consortium shall be binding on consortium partners. Clause 7, the leader of the consortium shall be liable for performance of the equipment system on behalf of the consortium. And down below at clause 15, your lordship will find that this is irrevocable. It is further agreed that this MOU shall be irrevocable and shall form an integral part of the contract and shall continue to be enforceable till the purchaser discharges the same.
Mm.
Now, my lord, if your lordship has the tender conditions under which a consortium is permitted to bid, that your lordship will find at clause 3.5.6 of the NIT, which your lordship will find in going back to the first volume itself, page 281.
Yes.
It is under this clause that a consortium is permitted to bid. And how it will bid, your lordship will find various clauses which say that it is entirely the lead partner who will deal with the NIT. For example, my lord, if your lordship sees clause 3.5.
This clause was brought to the notice of learned single judge.
I had argued, my lord, I can place my arguments. Unfortunately, my lord, at the time of arriving at the conclusion, these clauses were not really taken note of. If your lordship first takes up clause C, my lord, subclause C, the consortium must be valid for minimum period of 12 months after the completion of the contract. So we could not have even bid had we not made it clear in the consortium agreement itself that it is valid for after 12 months of the completion of the contract itself.
Is it a condition in your agreement?
Yes, very much.
Can you please point it out?
While my junior my lord, takes it out, may I?
Yes.
While we
Carry
are
on.
on this page, my lord, may I
Carry
point
on.
out some
Yes.
further clauses which will be
Carry on.
relevant.
Carry on.
If your
please.
lordship will kindly come to clause E
Yes.
at the next page.
Yes.
This is even more important.
Yes.
The bid shall contain copy of the original memorandum of understanding between the consortium partners. Next sentence, my lord. The MOU shall be converted to a definitive agreement between the parties after award of job and before signing of the contract. It shall be done within 15 days from the date of issuance of the letter of acceptance. So, in a sense, the lead partner is to continue to deal with the authorities, and only when the contract is awarded, they are required to convert it into a definitive agreement.
Right.
Now, my lord, clause I. One participating member of the consortium shall be identified as prime member and has to be an Indian bidder or Indian subsidiary of a foreign company. The prime member shall be authorized to incur liabilities and receive instructions for and on behalf of all partners of the consortium, and the entire execution of the contract, including receipt of payments, shall be done exclusively through the prime member. Next, clause J. The prime member of the consortium should confirm unconditional acceptance of full responsibility of the of executing the entire scope of work of this tender. Now, my lord, if your lordship kindly turns over to the next page, subclause N.
Yes.
Prime member of the consortium on behalf of the consortium shall coordinate with the owner during the period the bid is under evaluation and also during the execution of the contract.
Who would be the owner?
Owner will be the authorities.
Authorities. Okay.
Now, if your lordship kindly comes to subclause O,
Yes.
any correspondence exchanged between NRL, that is the owner or the authority, and the prime member of the consortium shall be binding on all constituents of the consortium. Now, even the payment, subclause Q, payment for work done under the contract shall be made by NRL only to the prime member of the consortium. So basically, it is the lead member who is required to deal with the authorities. And even under the law, my lord, which the Honorable Single Judge has rightly accepted my argument, that there is a fundamental difference between a consortium and a joint venture. And thereafter, my lord, towards the later part, while arriving at the conclusions, my lord, the Honorable Single Judge goes on to rely on a judgment pertaining to joint venture and dismisses my writ petition on the ground that I wouldn't have the locus. And thereby, my lord, the Honorable Single Judge did not even go into the merits. Perhaps, my lord, this is a case where your lordship may like to examine it, admit it, and
Yes, Mr. Das, what do you say?
I filed an application before the learned single judge. I was awarded with work. Somewhere in May 2021, I was awarded with work.
Okay.
He comes to October 2021. Now, my lord, the work was given to us. We started the work. May 2022, a writ petition has been filed.
Let us admit it. It's a question of academic importance.
One of the bidder participated in the NIT, my lord. Both the bidder consortium participated. Now, one of the bidder comes, one of the consortium members come before this honorable court.
The other is a
Not the
respondent.
other.
The other
Why?
is the
Because
respondent.
We came to know March 2022, he sold this all cargo has sold all this logistic management. He sold it. So, my lord, distribution of work, my lord, declaration. And
Basically, Senior Counsel is just asking us to decide the academic issue involved in the matter.
no, but it will have, because although they say that we came very late, we came in May. The agreement, the contract was awarded, the contract was entered into in June. I can place the document from their own.
The tender was accepted in 21.
We will start, started the work is an important project, my lord. Expansion of a refinery, my lord.
Admit issue notice. So and so are duly represented. Thus, notice need not be issued to such respondents. Steps for service on the unserved respondents. Everyone, every of this, each of respondents is.
All are
represented.
represented. Your lordship may, considering the ballot, otherwise perhaps the matter itself will become infructuous. If your lordship fixes an early date,
Not
as,
right now.
as per your lordship's convenience,
Not right now, not right now.
towards the end of April.
We will see, sir. Wait for your turn. Admit it
This
to
is
notice.
purely a
Respondents are duly represented, thus process need not be issued.
Oblige.
You have accepted part of your prayer. Now you bear with us
I'm grateful.
regarding the other part.
I'm grateful, man.
Yes,
Item number 34 of supplementary list.
yes.
May it please the Lord.
Yes.
My lord, here lordships directed the government to file an affidavit whether that particular procedure which was prescribed is gazetted or not. My lord,
Yes.
the state has filed an affidavit, it was gazetted.
So then now what remains?
Then it will go in my favor.
It goes in your favor.
Yes.
Okay.
My lord,
Please
my
re-
settlement
please
was interfered with.
Reiterate the facts. Your
Yes.
settlement was
Yes.
interfered.
Now, what had happened, my lord?
Acha, it is that Goshala matter.
Not Gosala, my lord.
Okay.
Is that fishery settlement? matter.
Fishery settlement.
Yes. What had happened, my lord?
Yesterday there was a matter in which you are appearing.
Yes, yes, that
It was Gosala.
matter. Yes, yes.
Yes,
My lord, here in this case, on 8/3/2021,
yes.
this particular fishery was settled with the, my lord, Appellate Society. Now, recently the learned single judge has, my lord, interfered with the settlement on the ground that, my lord, the certain norms which were prescribed by a notification, those were followed by the settling authority. Now, one of the
Those
ground
were not followed.
is not followed. And one of the, my lord, reason which has been assigned by the learned single judges that there is no clarity whether it was gazette notification or not.
Okay.
Now, the fact remains, my lord, because of the affidavit filed by the state.
Notification is now on
Yes.
record.
Yes. The gazette is on record, my lord.
Okay, okay.
For example, my lord, the fishing certificate who will issue? Now, if your lordship that kindly come to that notification is at page
Please read
130.
the finding in the single bench judgment regarding notification.
Yes, yes, yes. My lord will kindly come to page number 130,
Para 15.
para 22, my lord.
Right.
There are apparently 3 grounds of rejection. It is, however, to be noted that price bid of the petitioner, said petitioner is found to be highest. 3 grounds are that fishing experience certificate is issued by the fishery extension officer instead of DFDO, that is District Fishery Development Officer, in the name of the president of the society and does not cover all the members of the society. The second ground is that neighborhood certificate issued by DFDO Morigaon and not by the revenue circle officer, who is stated to be the competent authority as per the government circular dated. This is the circular 18/118.
Yes.
Thirdly, no attestation of the resolution of the society in authorizing the president to submit the tender was found. These are the 3 grounds on which, my lord,
Yes.
the tender of the petitioner respondent was rejected. In response to the said ground, it is found that first ground of rejection is squarely covered by the decision of this court in case of Malegar Govindapur Fishery Cooperative Society, which has also been upheld by division bench. My lord, in the judgment, my lord, there is no reference to this 18/118 notification. The court also finds force.
No,
in
that
the
is regarding first ground, not the second ground.
first ground, yes. This
Yes.
court also finds force in the contention made on behalf of the petitioner that the NIT did not specify the authority to issue such certificate, and in any case, fishery extension officer cannot be held to be an incompetent to issue such a certificate.
Yes, yes.
This court also finds force in the argument of the petitioner regarding second ground of rejection on the competency of the DFDO Morigaon to issue the neighborhood certificate. Regarding the third ground of rejection, Sri Bhattakur, learned counsel for the petitioner, is correct in asserting that there is no such requirement of resolution being attested in view of the person who represents the society. In view of the above, the attestation would be relevant only when there is a complaint in regard to the authority of the representative of the society from among the members of the society, which is not found in the instant case. As regards the gazette notification dated 18/118, though certain doubts have been expressed by this court in case of Gauripur regarding its application and also the question of its publication in gazette, The said notification being placed on record, which is in the form of a gazette notification, this court is of the opinion that said point will not act as a hurdle for this court to acknowledge the said notification. However, more so that more than in existence, what is to be decided its applicability of the conditions of the said notification in the tender process. Mr. Sharma, Learned State Council has strenuously argued that gazette notification is of the year 21 and NIT is of the year 21, and therefore it cannot be assumed that all the intending tenders are not aware of the requirement of law. However, having taken into consideration, this court also cannot ignore that condition of the gazette notification, which requires that all ensuing tender process has to incorporate the conditions given in the gazette notification, which admittedly has not been done. It is trite law that while applying a notification, it cannot be done in a way that only those in favor of the state would be made applicable and those which are against cannot be applied.
What is the import of this finding?
The import of this finding is, my lord, the gazette note, my lord, the learned single judge did not lay any importance to the effect of a gazette notification, either notification or there is no notice.
Your client was compliant of this notification.
Yes, I am compliant. That's why, well, if a lordship would kindly.
Client certificate, neighborhood certificate was issued by the revenue authority.
As named in the notification.
As named in the notification.
That settlement order makes the position clear, my lord. So lordship would kindly come to page 52.
Yes.
Now, my lord, technically the writ petitioner was highest, but I am the valid highest.
Yes.
Now, serial number 2, Teteliguri Nobojyoti, this is the writ petitioner. The society has offered bid of rupees 2.69 crores, which is highest.
Yes.
The fishing certificate is issued by one fishery extension officer of the district development officer Morigaon in the name of president and does not cover all the members of the society. The neighborhood certificate is issued by DFDO Morigaon, but concerned revenue circle officer is competent to issue the certificate as per government circular dated so and so. No attestation resolution of society authorizing the president to be present to be submit the tender is found with the tender. So, my lord, these are the 3 informatives found in the writ petitioner's tender. Serial number 4 is the appellant. Pakoli Duba means by committee. The society has offered 1.99 crores. All documents submitted with the tender found to be ordered. Now, my lord will kindly come to page 53. Now, regarding the position of the bidders. From the above, government is of the view that there appears to be wide publicity of the NIT for which 12 number of societies, 10 from Morigaon and 2 from Kamrup Metro, participated in the settlement process. Out of the 12 bids, only 3 bids are found valid as per the documents that are submitted with the tender in terms of the NIT as shown below. Pakolidoba has offered 1.99 crore at the rate of the highest valid bidder, overall 5th highest, and members residing in the notified villages as per registration certificate are within 5 kilometer radius of the fishery as per neighborhood certificate. Mayong so and so is the second highest. So, my lord, amongst the 12 bidders,
you are the compliant bidder.
Highest.
2 are well qualified, and you are the highest.
So, my lord, the settlement was given to me. Now, learned single judge says you could not have relied upon this 18/128 circular because it was not properly, gazetted and was not made part of the tender process. It is in that context, on the last occasion, lordship was pleased to
Publication
government advocate to find out whether it was gazetted. If it is gazetted, then, my lord, one cannot plead ignorance of law. That was the purpose.
Okay. And your client is continuing the fishing activity.
My lord, till date we are continuing.
Okay.
And because, my lord, the other lordship also indicated to government till day after tomorrow, at least ensure that no coercive action is taken.
You are for the writ petitioner.
Writ petitioner.
Yes. What do you say?
Lordship, so far as this notification is concerned, your lordship may come to page 134 again, your lordship.
Yes, please. 134.
Lordship.
Right.
Second para onwards, it is therefore felt that there is no need for streamlining the procedure for submission of information documents with tenders so that there is uniformity in all such tenders to notice inviting tenders.
You are referring to the following clauses are to be included.
Yes, your lordship.
All right. Even if it is not included,
No, your lordship.
the notification has the status of law.
No, your lordship, that is there, but your lordship, if this notification has the status of law, your lordship, it is incumbent on the part of the tendering authority to include this in the tender notice.
Very well.
Your lordship.
Okay.
If it is, your lordship will kindly note, your lordship, they cannot say that this is not mandatory for us, but this notification will be mandatory for the tenderers, your lordship. That, in my humble submission, your lordship, that will
All
defy
tenderers,
logic, your
all tenderers are in the same position. If
lordship.
they were aware of the notification and its implications, and they got the neighborhood certificate from the proper authority, what prevented you from doing it?
No, lordship, you kindly note one aspect, your lordship.
Yes.
It is not that, your lordship, ultimately what will happen, your lordship. This is the conditions to be incorporated in the.
That you already
tender,
argued, Mr.
terms of the
Counsel.
tender.
Yes,
Now, your lordship, they did not include it in the terms of the tender, your lordship.
you already stated, sir, we
No,
understand.
no, your lordship will kindly see the moment the government relies on these conditions, your lordship, it amounts to, your lordship, amendment of the terms of the
Terms of the
tender, your
tender.
lordship.
Okay, and the case is required to be considered, admit, stay on the single bench judgment.
Your lordship may kindly fix a date, your lordship.
We'll hear it when the turn comes.
Deeply. Deeply.
It's 12.
Obliged,
Is
sir.
on. Then, at 12:50. 12:50. Yes, it's next in the list. No, habeas corpus. Hearing matters are starting. Order matters complete करिए, उसके बाद देंगे. We'll take the habeas corpus at 12:50.
Item number 22,
Habeas corpus is at serial number 29. Okay.
Otherwise, my lord, as per instruction, my lord, it has become infraction.
Which one? 20, that habeas corpus?
No, my lord, it is.
Okay, 22. Okay.
22, your lord.
So we'll record your statement.
My lord.
Land counsel for the petitioner states that controversy involved in this.
Not corpus, my lord, this is matter not habeas corpus.
No, you are talking of item number 22.
22, your
Yes,
lord.
controversy involved in this writ petition does not survive, and thus, the matter may be disposed of as infructuous in view of the statement so made, the instant writ petition within bracket PIL is disposed of as having rendered infructuous by subsequent events. All pending applications, if any, are also disposed of.
Deeply.
item number 23,
Yes.
May it please, your lordship. My lord, as per office note dated 28/12/2022, my lord. As per office note dated 28/12/2022, my lord.
Yes.
The notice has been served, my lord, except, my lord, respondent number 16, my lord, whom we have tried to serve the notice to Dusty, my lord, and he refused to accept, my lord.
Is there a report of
Yes, my
refusal?
lord, we have, my lord, filed an affidavit to that effect, my lord. That this
Different file for affidavit. So can you point out where the affidavit of service is there? Please. You're talking about respondent number
respondent number 16, my lord. My lord,
16.
yes, my lord. My lord, we have,
The writ petition is filed in relation to what controversy?
my lord,
Against the order of CAT.
yes, my lord.
Okay. Station Master Lumding.
My lord.
Okay.
Otherwise, my lord, all the notices has been served, my lord. And my lord, my friend is appearing for respondent number 1 to 5. And others are, my lord, those served, my lord, they have not.
They are not represented.
My lord.
Okay. Then the process is that if Notice post admission has been served and no one comes. Writ petition has to be admitted then.
Yes, my lord.
All right. Learned counsel for the petitioner has filed affidavit of the service upon the respondent number 16. As per the office report, service has already been effected on other respondents. Respondents numbers 1 to 5 are represented by learned counsel so and so. As no one appears for the private respondents numbers 6 to 20 despite service, the writ petition is admitted. Admission notice, Mr. So and so waive service on behalf of the respondents numbers 1 to 5. Let service post admission be effected on the other respondents by registered AD post.
My lord.
Notices will have to go again
Yes.
after admission.
Yes, my lord.
Yes. He will take it up at 12:50, along with the habeas corpus, one after the other. Yes.
Deeply.
Item number 25 and 26.
Lordship, these matters are parted before court number 7 as per order dated 22.
These are parted.
Lordship will see order dated 20/02/2023.
Lordship, those two matters, I don't know how it's tagged, because one is, yes, Lordship.
You know, Mr. Chaudhary, a matter which is not admitted can't be parted.
Lordship, I just.
That is what the procedure is.
Lordship,
Matter only post being admitted
Lordship,
can be marked as parted.
Lordship, I leave it to you, Lordship.
Yes.
May I submit, Lordship?
Hmm?
May I submit, Lordship?
Yes.
My lord, though, because this PIL is a different issue and the writ petition which is tagged, I don't know how it's tagged.
We don't know, madam. Must have been an earlier order.
So order dated 28/2.
28/2.
Because on last occasion, learned friend, senior friend had taken time to file rejoinder affidavit.
In
the PIL law.
PIL.
Yes, Lordship, and there are.
Why this writ petition is tagged? Let us
That is
know.
the different issue, Lordship, altogether. My humble prayer is let this better be detagged, Lordship.
Just hold on. What is the prayer in your PIL?
My prayer in the PIL is, Lordship,
Food
providing.
security
Yes, Lordship.
to families in villages
Yes, in the 3 districts of Arunachal Pradesh.
where there are no ration cards.
Yes, Lordship. And even Anganwadi centers, Lordship, in various villages, there are no Anganwadi centers. So with that,
Why this writ petition has come to Guwahati?
this writ petition is separate issue of Assam, Lordship. And this is the reason I'm worrying why it's.
Actually, madam, this was filed.
No, PIL. Why PIL is in Guwahati?
At that time, when COVID situation was there, Lordship and similar kind of PIL with regard to the state of Assam was filed here in the principal seat.
Okay.
So prayer was made before this honorable court, before Lordship, to allow to file the similar kind of PIL.
So now can we send it to Arunachal Pradesh? It will be dealt with better, in a better way.
Otherwise, it can be heard here also.
Very well, all right. Continue then. So what do you want in PIL today?
Today, Lordship, my humble prayer will be, let the union file their reply, Lordship. They have not yet filed their reply. And as per order dated, Lordship, 23/5/22, there was a direction for the central government to file their
Mr.
reply.
Chaudhary, in the writ petition, the issue is regarding rights available to a declared foreigner. Writ petition.
That the other case.
Yes, so how it is linked with the PIL?
Lordship, here in the first case, the PIL pertains to the Chakmas and the Hajongs, who are not citizens of India. Who are not declared citizens of India. Now, they are also seeking some rights. And the other case also. Now, at that point of time, Lordship, the learned court wanted to know whether all the rights would be available to citizens or non-citizens.
Yeah.
That is why.
Right. Food security is a right of everyone who is in the country,
Yes.
irrespective of citizenship.
Yes.
There is also the Lordship.
But Mr. Chaudhary, if you read the PIL, there is no such indication therein that it is for particular communities.
Yes, Lordship. My
Read.
humble prayer is that.
How do you get it from that? These are for people who are not citizens of this country.
Yes, Lordship.
There is some reference, Chakma and Ajong,
Yes.
living in the village of so and so.
Yes.
Okay, they don't have ration cards, that's why.
They don't have ration cards.
Ah.
That is the issue.
Okay.
Otherwise,
There are other
citizens
communities
would
also
normally
as well,
have. And
Lordship.
here is a case, Lordship, where they were confined to a particular area. Lordship, I have even given 3 judgments to the court master, Lordship. In fact, they were confined to a particular area. They had come in the year 1972 from
Okay.
the Chittagong area. Due to religious persecution and all those things.
Naturally.
Initially, they had come to Assam, then
There
they
are
were-
similar camps in Rajasthan.
Yes,
People migrated from Pakistan after 72 war.
thereafter they were put in Arunachal Pradesh, Lordship.
Yes.
Now, whether they would be granted citizenship, they would not be granted citizenship, now that aspect is Lordship
different.
imposed by the state.
Yes.
And Lordship, my humble.
But
submission
anyway,
is
this
that
writ petition
64.
doesn't have any connection
Yes, Lordship.
with the
Yes, Lordship. That way, my humble prayer is that we will detect.
Learned Council, MS so and so, representing the petitioners in PIL number 41/21, submits that controversy involved in this writ petition has no connection in this PIL, has no connection whatsoever with the writ petition with the one involved agitated in writ petition number 7632/2022. Shri R.K. Dev Chaudhary, learned PSG, also does not dispute this submission in view of the above, the file of writ petition number 7632/22 shall be detached and listed separately before appropriate bench. What is to be done in this writ petition today in PIL?
I am appearing in item number 26.
Hold on, we are talking of PIL.
My lord, in this.
Affidavit.
Yes. Lordship.
Shri R.K. Dev Chaudhary, PSG, appearing for the Union of India. Case for is granted 4 weeks time to file counter affidavit.
In fact, Lordship, the whatever has to be done has to be executed by the state. I'll file a short affidavit.
File an affidavit. And writ petition, what do you want? Yes, Mr. Counsel.
Yes, my lord. Please, Lordship, my lord.
Yes.
As per the last order, my lord, there is no such indication that this, my lord, writ petition may be tagged with this PIL, my lord.
That,
In fact, Lordship.
that
I
is the
should-
order in the PIL.
PIL,
Yes,
my lord.
Lordship.
Yes,
Now, if your lordship kindly considers my lord writ petition, my lord,
yes.
and by virtue of earlier order, my lord, I was declared to be a foreigner, my lord. If your lordship kindly turns to page 42, my lord,
Yes.
annexure 11 of this writ petition, my lord.
Hmm.
I was declared to be a foreigner, my lord.
Yes.
Thereafter, my lord, I preferred a writ petition before this honorable court, my lord.
Hmm.
The next annexure, my lord, page 45, my lord. Annexure 12, my lord.
Yes.
And that was, my lord,
This
dismissed, my lord.
was there. All right, this writ petition, let this writ petition be listed before division bench number 2.
Two, my lord.
This goes to division bench 2.
My lord.
Okay,
In
as
fact-
per roster.
In fact, on the last day, it was heard there. Once
This,
it
there was no cause to tag the PIL.
was
Yes,
possibly, my lord.
Yes,
Sir, may I pray for one thing, my lord?
yes.
First, will kindly, if possible, a date may kindly be given.
We can't fix the date for the other
My
court.
lord.
You have to make a request there.
Item number 28,
Obliged.
Yes.
But as per earlier order, the 24/1/2023, the state is required to deposit an interim payment of rupees 5 lakhs, madam. So that amount has been sanctioned, madam, yesterday.
State.
Yeah, yes, madam.
Okay.
There's an
It has
interim
been
direction.
sanctioned.
Yes, madam.
Okay.
Yesterday it was sanctioned, madam. So it will be deposited in the registry of this honorable court, madam, within a week, madam.
Learned Council, Mr. Your good
And-
name?
NJ Khatuniya, madam.
NJ Katniar, Standing Council Education Elementary Department, submits that sanction for depositing the arrears of salary to the tune of rupees 5 lakh has already been issued by the communication dated 14/3/2023, and that why it will be deposited in the registry That is the order.
That is the direction, madam.
and that the amount will be deposited in the registry of this court tomorrow
No, we need 2 or 3 days, madam.
within next 3 days.
Yes, madam.
My lord, the matter has to be heard finally. It's regarding, my lord, area salaries of one of the teacher.
Okay, so upon the amount be deposited accordingly on or before 21st April, 20th March, the writ petition, the appeal shall be listed for hearing in June,
My lord, it should be early, my lord. There is
in the month of May 2023.
Oblige lordship.
Item number 30,
May it please your lordship.
Yes.
Lord, as per honorable High Court order lordship, I have filed the affidavit, my lord, regarding the procedure followed by the dealer for registration of the vehicle, my lord.
Yes.
Lordship may kindly have a look my affidavit, page 85 onwards, my lord.
Page number
85, my lord.
85.
My lord. Paragraph 3, my lord.
85. Yes, please.
Paragraph 3, may I read, my lord? That the deponent begs to state that an application for registration of a motor vehicle is made in Form 20, accompanied by other requisite documents like Form 21, this is sales certificate, Form 22, roadworthiness certificate, address proof, etc., as per Rule 47 of the CMVR 1989, and the scanned documents are uploaded online at the software. The requisite fee as per Rule 81 of the CMVR 1989, a route tax are auto-calculated by the software based on the required information available in the manufacturer homologation without any human intervention. Then the deponent for the begs to state that in regards to Aadhaar authenticated registration process, one-time password OTP is received at the Aadhaar link mobile number of the applicant. Thereafter, on insertion of the OTP, the owner details are automatically filled up on the basis of Aadhaar details. Furthermore, while entering the data regarding the vehicle details, insurance details, hypothetication details are made by the dealer, followed by the uploading of scanned documents, dealer verification, fee tax payment, SSRP number assignment, affixation and dealer's approval, and card printing and dispatch. That the deponent further back to space that in case of non-Aadhaar authentication registration process, OTP is received at the mobile number of the applicant possessor of the vehicle linked with Vahan software, followed by the same processes as in the case of Aadhaar authentication registration process. Then 6, my lord, that the deponent begs to state that amongst other requisite documents, one identity proof is accepted and uploaded online by a dealer during the time of new registration. Furthermore, OTP is received at the mobile number of the applicant linked with Vahan software, my lord. Furthermore, as per order number so and so dated 29/8/2020, the registration certificate are to be delivered by the post to ensure accuracy of the address provided. Then my lord may kindly have a paragraph 7.
Yes.
The deponent begs to state that as per Rule 48B of CMVR 1989 relating to production of vehicle at the time of the registration, a motor vehicle sold by an authorized dealer shall not require production before registering authority for the purpose of registration for the first time if it is fully built motor vehicle, provided then an officer not below the rank of motor vehicle inspector of the motor vehicle department may randomly inspect any vehicle in the inventory of the premises of the dealer. Then the deponent begs to state that all the documents that are uploaded are available on the Vahan portal, my lord. The details may undertake random checking and as and when required and conduct periodical inspection of the automobile dealers. Lordship may kindly have a look, paragraph 9, my lord. 9 is, okay, then Lordship may kindly have a look, the paragraph 11 for a moment.
Yes.
That the deponent begs to state that an automobile dealers must obtain trade certificate from the registering authority having jurisdiction in its area in which the dealer has its place of business in accordance with the chapter 3 of the Central Motor Vehicle Rules 1989. The trade certificate is granted as per Rule 35 of the CMVR 1989 by the registering authority, which is the district transport officer for this purpose, after being satisfied that the applicant is a bona fide dealer or a manufacturer of automobile ancillaries or a test agency specified in Rule 126 CMVR 1989. While granting the TC, the address and the other details of the applicant are thoroughly verified by the DTOs, my lord. Then 12, my lord, then the deponent begs to state that the availing service available for automobile dealer on the Vahan portal, dealers are required to contact the DTO along with the valid TC to get user credential of the portal. The DTO creates the login credentials such as the user ID and password for all those dealers under his jurisdiction from the district admin ID of Vahan, and these are handed over to the concerned automobile dealer with instruction to change the password immediately, my lord. Then lordship may kindly have a look, paragraph 14 for a moment, my lord.
Yes.
That the deponent beg to state that subsequent to granting the power of registering authority to the automobile dealers, the role of scrutiny, approval and RC printing are given to the automobile dealers against the existing Vahan login ID given to the automobile dealers. In case new automobile dealers, if the dealer applies for TC, subsequent to granting the power of registering authority to the automobile dealers, granting of TC is followed by creation and handing over to user credential, login in ID Vahan portal to the automobile dealers by the DTOs, my lord. Then Lordship may kindly have a look, the paragraph 17, my lord. That the deponent beg to state that the documents required to be submitted by the purchaser of a new vehicle are authenticated as per Rule 172 of the CMVR 1989. This is the page 40 annex 4 of the PIL petition. The Lordship may kindly dismiss this PIL. They have no locus. In fact, this honorable court has earlier observed in order to the 15 to Lordship may kindly have a look.
This very petition?
My lord, this page.
Yes.
The order dated 15 to for a moment.
Yes.
May I read, my lord?
Yes.
The petitioner on the next returnable date shall first focus as to what is the locus of the petitioner. and
Yes,
in
yes,
what
we have read
manner.
it. We have read
Yes,
it.
my lord. Lordship may
What do you say, Mr. Counsel? Technology has invaded our lives.
Yes, my
Forget about these niceties.
Yes,
This is all technological development.
my lord.
You have to say anything.
I want to.
Your bona fides are in question.
Yes, my lord.
You are opposing advent of technology
No, I'm
by
not
this bill.
Advent of technology.
Then
I have to point out two things, that only the verification and authentication of the documents to be done by the DTO.
everything is uploaded. Everything is uploaded.
In their
It is linked to
affidavit-
Aadhaar.
Yes.
What is to be done then?
In their
Yes.
affidavit in paragraph number 8, they are saying that the DTO may randomly.
Check the vehicle,
check. No,
not the
check
documents.
Checking periodic inspection of the dealers. May I read the?
Yes, so
The deponent begs to state that all documents that are uploaded are available on the Vahan portal.
yes.
The
So-
DTOs may undertake random checking.
Yes.
Now the SOP they have published, that is by page 21 of the petition,
Yes.
paragraph number 4. As per GSR number 240E dated so and so, the records of vehicle registered is allowed to keep in electronic form. Hence, it is not necessary to send copies of vehicular documents to the district transport officers by the authorized.
Hard copies.
Hard copies.
So the soft copies are uploaded, they are received.
No, simultaneously.
Mr. Counsel in Odisha, 10 benches of the High Court have been constituted by virtual mode.
Yes.
You are now arguing about things which are obsolete, dismissed.
Yes, my lord. I'm deeply obliged, my lord.
This is not thing which is required. The technology. Why am I required to put the people? Everything is uploaded, he is given the authorization. Registered, download. Yes.
I'm deeply obliged, my lord.
Matter number 31.
My lord, can I have a look on the last order 24 to 2023?
Yes, please.
Direction have to file all the instruction by open affidavit.
Yes.
Here I have got the, my lord, instruction, my lord. I pay for a week's time to file my affidavit.
Then
Entire
counsel-
reports are there, my lord.
Respondent, Ms. Boyan,
Big over, my lord.
B.B. Gogoi appearing for the response numbers 2 to 12. Praise for and is granted 2 weeks time to place on record the facts, relevant facts in form of an affidavit by way of compliance of the directions given on 15/2/2023, reiterated on 24/2/2023.
Well, I appear for 1 to 6, not
1 to 6.
Yeah.
List of 2 weeks.
Matter number 32.
IE. What is the IE?
Ma'am, please, Lord. My lord, it's an appeal file under section 260 of the Income Tax Act. Lordship, there is a delay of around 33 days, Lordship.
Or we'll take notice, my lord. I'm appealing for the sole respondent, Maliga.
So do you object to the delay being condoned?
My lord, because there are other connected appeals also, my lord, where we have taken the stand, my lord. Lordship will fix it
Okay.
after 2 weeks, my lord.
And counsel for the respondent, appearing for the respondent in caveat.
We had initially KVIT, my lord.
Okay, caveat has already been discharged.
No, my lord. It is actually KVIT has expired because 3 months.
Okay,
Yeah.
appearing for the respondent, praise foreign is granted time to file an objection against the application for condonation of delay. List after 3 weeks.
My lord. Deeply pleased. Item number 4, passed over.
Yes.
Well, this case, one, the last time. Sometimes back I argued that they sold out their auction property.
Yes.
Yes, which they have not supposed to sold without giving us a notice actually. And they have sold after what your lordship had, whether they have admitted, yes, they have admitted in their affidavit in para 12. In the affidavit para 12, that is replied to paragraph 14 of the petition, the answering and respondent deny each and every allegation and nothing is admitted which is contrary to the materials on the court.
Yes.
It is denied that there is any violation of constitutional legal right of the petition.
You know what is to be done, sir?
As the petition did not take away the movable unit, the bearer no other but to include the salvage value said good in the value of property sold in the auction dated 4/7/22.
Okay, so salvage value is there.
Yes,
What to
value,
do?
they are violate they do. But this is my personal belonging property.
Yes, so if you
And
don't
my lord, there are
remove them,
certain
if you
property,
don't
my lord,
remove the belongings,
certain property, my lord, which is cannot be measured in terms of money because some personal rituals.
you had the opportunity, sir. You had the opportunity. You were having
I don't have
notice.
the opportunity. First of all, when they have a contrary statement they are making. Now, what
Which-
they have said in earlier, they have stated in the letter that they don't have any, they didn't got any material. There is no such person beyond in their custody because if my lordship go through my additional affidavit, my lord, additional affidavit, I've stated the letter which they have written. Additional affidavit, my lord.
Yes.
Is annexer Q, page 136.
The possession was taken on 20th February 2018.
It is still then they are under custody, they are under their lock and key. We have no other.
Just hold on, sir.
Yes, my lord.
Any communication from your client in the intervening period saying that my belongings are lying there, please.
Yes, yes.
Let us see. Your list of dates doesn't mention any such communication.
There is none. That old representation we have not annexed, my lord. But there is a.
Sir, your list of dates even doesn't say so. Read out from your pleadings that your client represented that my belongings are there. Please let me take them.
Yes.
Read.
That petition, if you lordship go to page 10, para 10 in my writ petition,
Yes.
the petition way to submit that all the above writ petition preferred by the petition, more specific writ petition number 1. There are so many writ petitions. 1/83/2019, the petitioner categorically averred that she was not allowed to take her personal being from a dwelling house. A respondent has.
Sir, the query which we have put to you is that
Yes,
the
my lord.
possession was taken in 2018.
Yes, my lord.
Any communication from your client, any
Yes, yes.
representation
Yes.
saying that my personal
Yes, yes,
belongings
yes, yes. If you lordship go through my para 8, my lord, I will just read out. Para 8.
of your writ petition
Yes,
at
my
page number,
page number 13.
read please.
That the petitioner beg to submit that as a part of recovery process initiated by the respondent bank under provision of FSC for recovery outstanding dues, the respondent bank had forcibly taken possession of the above mentioned dwelling house of the petitioner without any prior intimation to the petition on 22.
Sir, you are running too fast. We can't make out head or
Yes.
tail of what you are saying.
The petitioner beg to submit that as a part of recovery proceeding initiated by the respondent bank under the provision of FSC Act for the recovery outstanding.
Sir, what we are asking you is any representation by the petitioner after the date of possession that such articles are lying, please let me take them.
Huh? But after that, my lord, 128, I have annexed 1/2 letter, my lord. If you lordship go through my letter. That representation is there, my lord. If you annex 129, my lord, annex P. This letter I have written, my lord. Scatters of mortgage, property and personal belongings kept inside the same. With due respect, I am the owner of the plot of land measuring so and so. In the district of commerce so and so.
Sir, please, Come to your earlier writ petition, a single word in that writ petition, then my articles are lying in the house. Come to page 104. There has to be a limit to made up cases. We are persuaded to dismiss this with heavy cost. We are letting you know right now. Read your first writ petition, please.
Yes, my lord.
A single word uttered therein that the articles were lying there. You get wiser by every day. Read, please.
Earlier petition I have, huh?
This petition by the same petitioner.
Yes, that's the date, my lord.
This is after the date of possession.
Yes, after date of possession.
By then you must have realized that your articles are lying there.
But I am not, that's what I am telling, my lord. I am not allowed to go inside, my lord.
Sir, you don't utter a single word in your earlier writ petition.
Yes, yes, just read out, my lord.
Read, please.
Yes. That I have read out.
Read, please.
Page 106, my lord.
Yes, read.
The petition page para 6. The petition begs to submit thereafter the respondent bank on 22/2018 forcefully took physical possession of the mortgage property of the petitioner.
Yes.
The dwelling house of the petition, more specifically in schedule B, without any invitation and by way of application.
So why didn't you make a prayer to the court that allow me to take out my personal belongings?
Petitioner further begged to submit that while taking possession, she was not allowed to take her personal belongings.
So all right, why didn't you make a prayer then that allow me to take my personal belongings? What happened to that writ petition? What is the order on that?
That order was actually regarding that auction sales, my lord. We have challenged that auction was stayed.
So you could have raised that argument. At least let me take my belongings out. What prevented you from doing so? And this writ petition also comes to be filed after 1 year of the seizure.
Yes, my lord.
Then, sorry.
My lord, that I want to file a counter affidavit. Some letter might be there. I will want to file a counter.
Nothing going, sir. Thank you. Dismissed.
But I will liberty that they are to file to go for the DRT, my lord. That liberty should be given.
You withdraw the writ petition. Withdraw it.
I withdraw it and let me.
Then after arguing the matter for some time, then counsel Mr. So and so gives liberty to withdraw the writ petition seeking leave that the petitioner may be approached to, may be permitted to approach the DRT for ventilating her grievances, the remaining grievances.
My objection as to limitation, I may also.
Learned counsel for the respondent has raised serious objection against this prayer, submitting that the proceedings before DRT now would be hit by limitation, bar of limitation. We make it clear that by granting this permission, we are not in any manner, condoning the delay, if any, which may occasion in filing the appropriate application before the DRT. The writ petition is disposed of as withdrawn with the liberty prayed for.
Item number 6.
Kanji, I'll dictate a couple of more lines. Yes.
May it be lordship, my lord. My lord, I know my position, my lord, here.
So then,
one day I can come, one day for your lordship.
Writing is on the wall, sir.
Yeah, my lord, one day, my lord, some time, my lord, 1 day, 2 months, one day for
Time,
I have no.
the entire
I know
jurisdiction.
where I stand, my lord.
Sir, please don't relegate us to the position of a DRT. You have been granted time. You go to the DRT, make whatever request you want to do. This writ is not maintainable. It is misconceived.
No, that is my.
You are just trying to buy time.
I say, I know my fire, I stand, my lord. That
Just trying to buy time, sir, not possible.
One
Thank
day,
you.
my lord, in the meantime, my lord, my another friend said already, sale also, my lord, took place, man.
So all right, then chapter closed.
So
The
that's why, my lord, you may be liberty to challenge the sale, my lord. That's my.
this writ petition has been preferred by the petitioner with a prayer to extend the time for making the deposit in terms of the order dated 8/2/2023 passed by the DRT Guwahati.
Yes.
During the course of hearing, then counsel for the respondent stated that the property in question has already been auctioned. Secured assets have already been auctioned.
Sales certificate has also been issued.
And sales certificate has also been issued. Faced with this situation, then counsel representing the petitioner craves liberty to withdraw the writ petition, seeking leave that the petitioner may be permitted to challenge the subsequent proceedings as per law, ordered accordingly. The writ
Right.
petition is disposed of as withdrawn with the liberty paid for.
We'll take all the praise of plea of limitation, etc.
Obviously.
That is,
Keep the
always
blessing.
there can be either. Obliged.
We are not taking away any of your rights.
Item number 24.
We need to take the habeas corpus. Okay, we don't have much time. So we'll take it at 2. The habeas corpus at 2, because 1 o'clock we are having the AC. Take these both the matters at 2. Both at 2. We'll take up the matter at 2 o'clock. Both at 2.